If you're here and you do not wish to testify, but you want a record that your name was here and present for the hearing, and also indicating whether you're proponent, opponent, or neutral, there's a white sheet. Please sign that and fill it out. If you have handouts, we ask that you bring 10 copies. If you don't have 10, we can have our pages help you make copies. Bring those forward when you bring your green sheet and just hand that off, and the pages will make distribution for us. Let's see, if you come here to testify today, we've got some requests. Speak into the microphone. It is what gives us our official record. When you come up, say your name, then spell your name. We are going to use the light system today. Obviously, with the number of folks we have, we're going with a 3-minute system. So you'll have 2 minutes of green, 1 minute of yellow, and then you'll get a red light and an audible alarm if you go too long. No displays of support or opposition to the bill, vocal or otherwise, are allowed in public hearings. Committee members that are with us here today will introduce themselves, starting on my right with Senator Rabel.
Good morning, everyone. I'm Jane Raybold, Legislative District 28, which is the heart of the city of Lincoln. Don't worry, I tested negative this morning, but I'm going to continue to wear a mask to keep everybody safe.
Good morning, Rita Sanders, representing District 45, which is the Bellevue Offutt community.
Hi, Ray Aguilar, District 35, Grand Island.
John Lowe, District 37, Shelton, Gibbon, and Kearney.
Good morning, Steve Halloran, District 33, Adams, Kearney, and Phelps County.
I'm Megan Hunt, and I represent District 8 in the northern part of Midtown Omaha.
My vice chair is Senator Sanders. Legal counsel is Dick Clark. And the committee clerk is Julie Condon. And our pages today are Quinn and Ryan. With that, we will welcome up Senator Cavanaugh. Welcome to the Government Committee.
Good morning. Thank you. It's my first time here this year, I think. This is my second bill. I should know that this is my first time here. Sorry, I'm kind of running around. We didn't have a quorum across the hall, so I had to make sure I was wrong.
Hey, it's a Friday morning.
It is a Friday morning after a long week. Good morning, Chairman Brewer and members of the Government, Military, and Veterans Affairs Committee. I'm Michaela Cavanaugh, MACHAELA-CAVA-NAUGH, representing District 6, West Central Omaha, Douglas County, and I'm here today to introduce LB 360. In my first 4 years in my time in the legislature, I've seen numerous flawed requests for proposals from the state of Nebraska and the process of review and reward to actual contract oversight. Since at least the 1980s, there have been computer systems that have never come to fruition in HHS and in the Department of Labor, poor decisions in privatized child welfare contracts, and oversight of those contracts, and the avoidance of bid letting for multiple bids. We've been chasing our tails on contracts because poorly managed processes and poor decisions by those in charge. Former Senator Kathy Campbell's very thorough investigation that resulted in LR 37 report that is still available on the HHS committee web pages made recommendations for improvements. Yet here we are again headed into court in a June hearing over the current Medicaid managed care organizations contracts, or better known as our MCOs, leaving us once again mired in accusations of poor process and legal limbo with restraint orders and lawsuit. The legislature has made recommendations, hired consultants, put out reports, and passed legislation. This year, we have a significant number of legislative bills intended to make changes to the procurement process, and I believe it is time we have an inspector general to provide further oversight of the process that lead to poor compliance, expensive fixes, and poor services for the adults and children of Nebraska we are here to serve. It's time for more transparency in that process, or at least more accountability. The game of dual responsibility, so no agency is truly held accountable, needs to end. I believe that an inspector general for procurement is warranted. A trained inspector general would have the time to focus on processes and implementations and could provide the legislature with a wealth of information from which to make decisions. An inspector general can do their work in a way that is least intrusive to agencies. The information they gather would come to the legislature and to the agencies being overseen. The goal is a collaborative effort to improve the process and root out waste, fraud, and abuse. The legislature has the duty to provide oversight of state agencies. We must be fiscally responsible for the taxpayer dollars, and without oversight by the legislature, who will hold the executive branch accountable to assure the public? We pass the budget and have the responsibility of oversight on the use of that appropriation. We have a whole division called fiscal to try and keep tabs on budget issues. It is our job. I have a handout. Sorry. Actually, I have two handouts. I'll give them to you both now. It's an excerpt from a document produced at Wayne State University in Detroit at the Levin Center. The Carl Levin Center for Oversight and Democracy was established in 2015 to carry on the legislative oversight legacy and vision of U.S. Senator Carl Levin from Michigan. The center provides research and information about and to all levels of government to advance effective governance and help shine light on public and private sector abuses. The report they compiled on all 50 states ranks the 8 categories of oversight. One is contract oversight. As you can tell by the lack of information for state contracting oversight in the Nebraska report, their estimation is that the legislature has basically no oversight of contract procurement or contracts. An inspector general would give a way to monitor the process of contracting before we are millions of dollars into a contract and are in crisis. Our special committees only try to clean up the mess once we are in crisis. The Nebraska legislature needs more tools for oversight and ones that are less mired in politics. I believe an inspector general for procurement is an appropriate tool to assist the legislature in our oversight role and will allow us to be more fair and transparent in our own efforts to ensure appropriate government oversight. I also included in the distribution I will call it a bill that I received from DHHS for $64,000 for a records request that I made. And this was in regards to the RFP process around those managed care organizations that I was speaking of. I spoke about this on the floor when I received this bill. So what happened is that our managed care organization contracts were up and they needed to go out for bid again. There were 4 bids. We have 3 contracts. One of our 3 contracts was not renewed, and I requested information around that because I had some concerns over some of the things that I came to find out about the contracting process, including that the CEO of DHHS was named as a reference for the new contract that was made, and the former chief of staff of Governor Ricketts, Matt Miltenberger, was also named as a reference, which I find to be, while not illegal, not using good judgment and not appropriate. And so I wanted to see why we would go with a new contract. And I like to say, I do not have a horse in this race. I don't care which contracts are kept or not kept, as long as we're doing the appropriate contracts. And I just wanted to dive in on the contracting process itself a little bit more to find out what was going on with this particular contract. There were other things about it that I found out that they had withheld information that would have impacted their scoring, and the department decided not to rescore. And so that led me to make the records request that they then charged me $64,000 with. So obviously I have not received the records because I have not asked the state legislature to pay $64,000 for us to receive these records. I have made numerous records requests over my 4 years, and as most of you are probably well aware, some of that has led to a special investigative committee. While I think that is our job, and I think it is appropriate, I also think that, as I said, that is mired in politics. I recognize that I am a Democrat in a conservative legislature, and when I make requests like this, it is going to be viewed a certain way. I am on the Health and Human Services Committee. We have an Inspector General of Child Welfare. They do all types of investigations, and I don't get access to that information. The chair of the committee and the CEO of DHHS get access to that information, but it is only when there is agreement between the chair of HHS and the CEO about what reports will come out that I have access to any of that information, as does the rest of the legislature. And I think that's a much more appropriate process because it doesn't have underpinnings of political agenda. Not to say that I have a political agenda, but I do recognize that it can be viewed that way. And I don't think that our oversight should be tied to political agendas. I think that the role of oversight is to do good governance. And so that is what brought me here today and why I thought that an inspector general would be an appropriate mechanism. Of course, if we don't move forward with this legislation, I will continue to do my due diligence on oversight of our state agencies and continue to make requests regardless of the cost that they try to charge me. So with that, I will take any questions.
All right, thank you, Senator Cavanaugh. Well, let's go ahead and go into the questions. Senator Rabel.
Thank you, Senator Cavanaugh. You had mentioned some historical reference to Senator Kathy Campbell introducing legislation. And since I'm one of the new kids here, could you give me more information on what happened to Senator Campbell's legislation? Did it get passed or?
So we created the Office of the Inspector General as a result of Kathy Campbell's LR 37. And so we have an Inspector General for corrections and we have an Inspector General for child welfare. And in my 4 years here, it has been very apparent that our procurement process is flawed. And we will see several bills, I think you have them all scheduled today perhaps, around procurement. And so that's when the Inspector General's office was created. And I'm just seeking to add to the Inspector General's authority.
Okay, thank you very much.
Okay, additional questions? I just have one here. The fiscal note, which most of our bills have huge fiscal notes, yours is relatively small. It simply establishes a inspector general and an assistant inspector general. That's kind of the way you see it and you want it?
Yes, I believe so. I did speak with our ombudsman's office, and I believe they will be here testifying in the neutral capacity. But that is how their offices are set up, so that would be.
Okay. No. All right. Any other questions? All right. Well, you'll stick around for close?
I might jump across the hall to make sure they have enough people, but I will close, yes.
All right. We'll if you're not here, we'll double check before we close out,
Okay.
just in case.
Thank you.
Okay, so if we could get proponents to move to the first row, I'll have some idea of who's next up here. All right. Proponents. Okay, we will switch to opponents. If you can move up to the front row. That tells me we got a whole ton of neutrals. All right, we got first opponent. Actually, I hate to make you move again, but you just want to take the chair.
Should I go?
Yeah, go ahead. Welcome to the Government Committee.
Thank you.
Oh, there you go.
Good morning, Chairman Brewer and members of the committee. My name is Amara Block, Amara Block. I am the Material Administrator for the state of Nebraska, which is housed in the Department of Administrative Services. Prior to my current role, I was General Counsel for the department, and prior to that, I worked in the legislature as committee counsel. I'm here today to testify in opposition to LB 360. LB 360 is concerning because it threatens our access to contractors. The bill gives a new non-law enforcement public official a warrantless, limitless power to investigate businesses and vendors merely because there is a financial connection to the state. To further elaborate a little, the scope of the Inspector General's power is unlimited, meaning that the new Inspector General can review anything the business is doing related to the contract with the state or otherwise. The person or business doesn't even have to have a contract with the state. They can just be contemplating entering into a contractual arrangement. On that point, it doesn't even have to be a contract. The bill specifies it just has to be a financial arrangement. Reading this bill broadly, anybody who has ever received financial assistance from the state or has paid a fee for an official record or for a license could be subject to the powers of the Inspector General. The trigger for an investigation is much less than the law being broken. It can be something as simple as improper performance. Who decides what proper and improper performance is? I think we have all in our personal lives seen instances where somebody or something could have done a better job. All the Inspector General would need to do is determine that a lawful action could have been executed better. There's also constitutional concerns here. The constitutional concerns relate to the separation of powers. Nebraska has one of the strictest separation of powers provisions and interpretations in the country. The bill most certainly crosses the line between branches. Section 6, Article 4 of the Nebraska Constitution states that the supreme executive power shall be vested in the governor, who shall take care that the laws be faithfully executed and the affairs of the state efficiently and economically administered. The new Inspector General is charged with the ongoing review of the efficient and economical administration of not just laws, but any action or activity, including lawful actions and activities, so as long as they can be considered waste or improper performance. Considering the reach of this bill, if companies, small businesses, or driver's license holders would now be subject to a special police power that could investigate their business or interrogate their operations and employees for virtually any reason or no reason, why would anyone want to do business with the state? If the availability of contractors disappears, it is foreseeable that this bill would chill participation in our state contracts, which would be detrimental to state operations, either resulting in the total absence of goods and services or astronomical prices from the providers that remained. We appreciate and share the belief in transparency, which is why our operations are already transparent through public postings and thorough responses to public records requests. Should there be additional inquiries needed, the legislature already has reasonable and constitutionally sound mechanisms.
All right. Thank you, Amara. Thanks for adjusting your speech for the time.
Yeah, sped it up.
Okay, questions for Amara? Senator Rabel.
Thank you very much for coming down to testify. And so I think from my perspective, maybe the public doesn't know, what are your current policies and practices on procurement? As a business owner, we customarily go out for at least 3 bids, 2 bids certainly at a minimum. And having served on the county and city council, you know, they have a great procurement process, and they compare many elements to make sure everyone is talking and comparing apples to apples. So could you just do a simple, quick, summary on how does the procurement process work? That's one question. And then I guess, is it customary when legislators like Senator Michaela make requests for additional information that they consider it, that they would send a bill? Those 2 questions.
Sure. Thank you for the question. So to try and unpack that a little bit, it is in the state's best interest to try and get as many bidders as possible, right? The more bidders, in theory, means lower prices. What our laws currently state, and you will hear more about this in the afternoon with some of those bills, but what our laws currently state is anything above $50,000 has to be competitively bid by a formal process. I have a very dedicated, passionate team that does procurement for the state of Nebraska, and they do a great job ensuring that the laws are followed. In following those laws, we have a website with bidding opportunities where all of our bid documents that vendors can bid on are uploaded for everything to see. In regards to public records and transparency, in addition to what's posted on the website eventually, which we do get a lot of requests for materials related to competitive bids, and most often it's just hey, these are available on our website response. I can't speak for any other agency about public records, but I used to oversee our public records process as general counsel. And during my time as general counsel, it was practice not to charge anybody. It would just take more time if it was a large request. So rather than charging somebody, we would just say it's going to take a while, but we're working on it. Does that answer your question? Did I?
A little bit. So does the state of Nebraska have no bid contracts?
There are provisions in law that allow us to not competitively bid. Yes.
Okay. Thank you.
You're welcome.
All right, additional questions, Senator Hunt?
Thank you, Chairman Brewer. Has your office contacted Senator Cavanaugh's office yet about these concerns or trying to come to any kind of compromise with what she's trying to accomplish here?
Thank you, Senator. No, not that I'm aware of. I don't know if there is a compromise or revision here that could cure the constitutional concerns.
Okay. Would you be willing to work with Senator Cavanaugh and other citizen stakeholders who care about what's in these contracts to provide information about the contracts for free? Because that's not happening. And what we see with these recent abuses of what are supposed to be really strong public records access and laws, and especially to those of us who are making laws and policy, we should be able to have this information. And so what are your thoughts on that?
I can't speak for other agencies. I can reiterate that DAS does have a commitment to transparency, and we, in my time overseeing public records, we only charged one person once, and I think it was $100. And that was because we had to essentially make a computer program to produce the type of, it was a weird area of law and a weird circumstance where we actually had to compile a record, which is not normally required. And so I cannot speak for other agencies, but DAS's policy is, don't charge, but just be honest with the amount of time it will take to produce the records.
Okay. I've had trouble getting records too from DAS and DHHS and lots of other agencies who I've had to file Freedom of Information Acts to even, see what we're funding basically. So I do think it seems like a systemic problem that, can you confirm that you'd be willing to work with her office on that?
On public records or this bill?
On this bill, on public records, on increasing transparency to a degree that's satisfactory to the legislature?
I cannot commit to any of those things. I can't speak on behalf of DAS or the administration as to curing the defects with this bill. I certainly think that we'd be willing to talk about transparency concerns, but I can't commit to any, action or inaction.
Okay, thanks.
All right, any additional questions, Senator Lowe?
Thank you. You went through very quickly some of the problems that this would cause. Can you go back through those maybe a little slower this time?
Sure. Sorry, I was trying to.
The time was you were
Yes.
being right on.
So essentially, if you read through this bill, this new inspector general would have the power to investigate anybody who has a contract with, is thinking about have a contract with, or even just have a financial arrangement with, right? So financial arrangement isn't defined. If you think about what that could be, it could be you paying for a hunting license or a driver's license or an official record that you need from the government. I don't know that the intent is that broad, but I think it certainly could be read that way. With respect to contracting, I don't believe that any business would want to do business with the state if, for any reason or no reason, the inspector general could come in without a warrant and look at any operations of the business related to the contract or otherwise, and interrogate their employees. I just don't see businesses signing up for that. It wouldn't be worth their money unless maybe their only customer is the state of Nebraska, and they have to agree to that. Does that answer your question?
Thank you.
Yes.
All right. Any other questions? Yes, Senator Rabel.
So how does the state currently handle any challenges from a bidder who felt that they were the low bidder and that the contract went to another company? How do you currently handle these type of challenges?
Sure. So we do have a protest process, which actually I will be testifying for later this afternoon. But we do have a process in place for aggrieved bidders to protest a determination.
And then is there Is there a group of individuals or what part of your agency or body, who has that authority to review and make a determination?
Sure. So if the competitive bid was bid by the State Purchasing Bureau, which is just a division of the Materiel Division under DAS, that protest would go to me. And then if they didn't like my decision, then it would go to the director of the Department of Administrative Services.
Okay, thank you.
All right. One last round around the table. Any additional questions? Yes, Senator Hart.
Is there anyone else from the department coming up behind you?
From the Department of Administrative Services, not that I'm aware of.
Okay. We have these systems of checks and balances, but don't you agree that legislative oversight is important to that?
I think that everyone in this room can agree that transparency is necessary and essential. The legislature has oversight ability, just like the LR 29 committee, right, that got together, and DAS testified under oath in that committee. And we produced all records that were not privileged that were asked of us.
Okay. But when we're trying to do oversight and it comes with a $64,000 plus bill, I don't, okay, thank you very much.
All right. Any more questions? All right. Thank you, Amara.
Thank you.
All right. Let's see. We are in opposition. Any additional testifiers? All right. Then we will go to neutral testifiers. Please come on up. Welcome to the Government Committee.
Thank you. Good morning, Chairman Brewer and members of the Government, Military, and Veterans Affairs Committee. My name is Julie Rogers, Julierogers, and I serve as your public counsel, also known as the Ombudsman, within the Nebraska Office of Public Counsel, a division of the Legislature. Within the Office of Public Counsel are currently 2 offices of Inspectors General, or OIGs, one for child welfare, one for the correctional system. The provisions of Legislative Bill 360, creating the Office of Inspector General of Nebraska Procurement, is similar to both OIG acts. I first came to work in the Office of Public Counsel as the Inspector General of Nebraska Child Welfare before becoming Public Counsel. I became certified as an Inspector General in 2012, and I remain certified. As you consider enacting the Office of Inspector General of Nebraska Procurement Act, I hope it's helpful to know how our offices function. The offices are to strengthen legislative oversight when it comes to the government systems. To my knowledge, the Office of Inspectors General for Child Welfare and the Correctional System are the only offices with the name Inspector General in them to be housed in the legislative branch of government. We take care to ensure our role in government accountability is clear, not to take the place of other investigations done for other purposes, such as law enforcement, human resource issue investigations, and the like. There is clearly no supervision of any public or private entity investigated by our offices, but instead we provide oversight and accountability by and through the legislature. The core values of any government accountability office, including the OIGs, are honesty, integrity, and trustworthiness. This is accomplished through government accountability standards of independence and confidentiality. The fundamental objective of inspectors general offices is to promote accountability, transparency, good government, and high performance. The offices of inspectors general are physically located in the Ombudsman's office. We have meetings, staff casings regularly. The Public Counsel also has more formal statutory requirements with regard to each Office of Inspector General. The Ombudsman's office does receive individual complaints about various issues related to state government, but most are related to a specific issue or problem with services by or through a state agency. A contract issue or question that arises usually becomes secondary to solving the problem with that state program or issue. Our capacity ordinarily does not allow our office to take a detailed look at problems with procurement or state contracts. An OIG for procurement would not only ensure that those problems are looked into in a more detailed way than what is possible at the current time, but an OIG would do so in a very particular and structured way. And I see my time is up.
Please finish up.
Okay. Accountability is key to maintaining public trust. Government accountability offices, such as the Office of Public Counsel, including the OIGs, are entrusted with fostering and promoting integrity in government. Crucial standards of our offices include independence, impartiality, and confidentiality. The offices take those standards very seriously, and objectivity is of utmost importance to us. And again, I'm happy to answer any questions.
All right, thank you for your testimony. Let's see if we have questions. Senator Riddle.
Thank you, Ms. Rogers, for being here. Did your office ever receive complaints from some of the contract issues with the St. Francis?
At that time, I was acting as Inspector General when that procurement process was underway. We certainly stayed abreast of the issues, but the priorities of the office were to investigate child and deaths and serious injuries. And so in terms of prioritization, the procurement and contracting, we certainly stayed abreast of the issues and would talk to stakeholders about those issues. But in terms of investigating the procurement process, there were other priorities of the office.
Okay, thank you.
All right, any additional questions? All right, thank you for your testimony.
you.
Thanks for giving us the printed copy so we can go back and look. All right, we are still on neutral testifiers. Come on up. Welcome to the Government Committee.
Good morning, Chairman Brewer and members of the Government, Military, and Veterans Affairs Committee. My name is Ryan Stanton, spelled RyanStanton, and I'm the CEO of Compass, which is a foster care and family service provider in Kearney, Nebraska, and I'm also the president of the Nebraska Alliance of Family and Child Service Providers. So we're an association of child welfare providers who individually contract with DHHS to provide child welfare services to thousands of families in over 60 Nebraska counties. I'm testifying neutral today just because I'm not sure exactly the issue that I bring up is being addressed by the bill that Senator Cavanaugh brought up, but still wanted to make you aware of the child welfare contracting process related to procurement. The state's child welfare services contracts run on a fiscal year from July 1st through June 30th and are reviewed annually. Every year, the department changes, edits, and tweaks the language as they should. Providers want and expect to be held to high standards, and families deserve the system to be based on high standards. Often providers receive these contracts with very little time to review the changes to get a full understanding of their impact before the contract expires. For example, in 2020, we received the final contracts, the final draft on June 23rd. In 2021, we received the final contracts on June 27th. In 2022, we received the final contracts on July 5th. Yes, you heard that correctly. We didn't receive those contracts until 5 days after the contract expired. At 9 p.m., we did get an email from the CFS director saying that contracts would be delayed a few days, but that was only after I sent a text to her at 8:30 saying we haven't received any information about the contract. So each provider had an individual choice to make. We could either refuse to provide services until we received a new contract, or which would cause disruption of services to families that we serve, and that would be incredibly harmful to their progress. In addition, we only get reimbursed from the state when we provide services. Therefore, we would have to tell our staff that they wouldn't be needed until a new contract is in place, and therefore wouldn't get paid. And in this job market, the majority probably would have found other jobs. The other option was to continue to provide services without a contract and hope for the best. And as far as I know, this is the option that every provider chose, and it worked out this time. Providers transported children thousands of miles across the state for 5 days, and as far as I know, nobody got in an accident or worse. We did have employees in people's homes, and nothing bad happened that I'm aware of. Keep in mind, this is all over a weekend that involves explosives. In the end, we were reimbursed for those 5 days, so the state and providers got lucky this time. I imagine it's unsettling for you to hear this story, both from the state's perspective and provider's perspective, but it's not a good way to do business. I just want to convey to you that it's very difficult to run a business under these conditions. And when we ask our contacts at DHHS what the issues were, they routinely blame procurement. Thank you. If you have any questions, I'd be happy to ask. Answer.
I got a hunch we will. Okay, questions? Well, I've got one.
Okay.
Let's back up just a little bit. So in a perfect world, these 5 days that ended up being kind of lost in the works here because of the timing on the contract, if it was done right and in a reasonable way, what would that have looked like? How much time would you have had to execute it?
Well, because there's changes every year to the contracts, ideally, we would receive the contracts 45 days in advance of the contract expiration to give us time to not only review what kind of impact they would have operationally, but also budget-wise, what kind of impact that would have. Because over the years, HHS has added language that would either decrease our revenue coming in from the state, or it would increase our expenses.
And equally, the taskers equate to the increase or decrease in the requirements for you then?
Yes.
Okay. All right. Any other questions? There we go.
Thank you very much for coming today. Did HHS follow up with a lot of the providers and give them additional information on what happened with procurement, or did HHS hold procurement responsible for the delays, or was there any exchange on, hey, how could we approve, or kind of a discussion like, hey, procurement, we tried our hardest, but we were waiting for this or that? I mean, was there any follow-up, not necessarily on your part, but on HHS part, and did they convey that?
Well, I mean, every year, because it was a routine issue, we would ask our contacts at DHHS, which would typically be the director or some of their designee, what the issue was related to the contracts and why the timeliness and sometimes errors in the contracts were issues. And they would routinely say, well, we got our contracts by this date to procurement, and then we didn't receive them until basically we sent them to you. So that would be the general statement.
Mm-hmm.
It never got specific. And so I'm unclear exactly what the issues might or might not have been.
So I appreciate that answer, but I'm trying to figure out who then has to come back on the procurement side. I guess, were you aware, Brandon, did HHS tell you about any changes? Well, procurement is going to change their policy, knowing full well that they're not giving sufficient a time for the contracts to be received, for them to process. Are they going to back up their date so that providers like yourself aren't left in this limbo? Did they say, hey, we're going to make some changes because we realized this wasn't very good business practices?
Are you talking about DHHS or procurement?
Well, I'm talking about DHHS working with procurement and saying, I think we probably need to back up our contract date for you, procurement, to receive the contracts from the individuals or companies that are bidding.
Yeah.
To help make sure that you don't get back in the same place, come June 30th. Are you going to be in the same place again this year? I guess in business, we like to hear like, okay, we didn't handle it this well in 2022, but we want to assure you, as a wonderful provider who's been working with us for years, these are the improvements that we've made.
Yeah. So we would routinely have statewide provider meetings, and starting at about a 6-month period before the contract expiration, we would ask where the contract's at. And so we were told by DHHS that they felt they got the contract from their perspective to procurement in enough time to receive it. That's as far as we got in the process.
Okay, thank you.
Yeah.
Right. Any other questions? All right. Thank you for your testimony.
Thank you.
All right. We are still in the neutral on LB 360. Anyone else neutral in 360? All right. Well, that will ask Senator Cavanaugh to come back up and give us a close.
Thank you, Chairman Brewer and members of the Government Committee. Senator Hunt, thank you for your questions. No, the department did not come and talk to me at all. They didn't express any of their concerns. They didn't ask if there were any changes that could be made. This is, of course, a pattern of behavior that we are experiencing across all agencies, is that they come in opposition to senators' bills without discussion. From my perspective, it is inappropriate for any state agency to come in opposition to a bill. They should be coming in neutral, and they should be working with senators to address their concerns in advance so that we can bring amendments that are made public in advance. So unfortunately, this is a pattern of inappropriate behavior. Yes, they did come under oath for LR 29 after I sought numerous records requests from numerous agencies. While I will continue to do this as part of my job, I do believe there are others that are better suited for this work, and I believe that is an Inspector General. As long as we do not have an Inspector General, I will continue to do my due diligence to provide government oversight and transparency for the people of Nebraska and taxpayer dollars. I think that if this is written too broadly, that there is certainly room for conversation about how that can be addressed. It is not my intention to make it impossible for the state of Nebraska to do business. It is my intention for the state of Nebraska to be the gold standard of how states do business. Frankly, I'm disappointed by the hyperbolic testimony of the Department of Administrative Services. I think it is outlandish to say that you can't get a driver's license. Extrapolating this to the bazillionth degree is unprofessional and inappropriate. And I, for one, am very tired of having this go around with state agencies. I don't think that this should be the role that I have to play every single day. I would like the role that I am playing is to enact strong public policy for the people of Nebraska and to ensure that we are spending tax dollars judiciously. I guess that's it.
All right. Thank you for close. Questions for Senator Cavanaugh? Senator Rabel.
Thank you, Senator Cavanaugh. I know this is tough, but are you going to continue your efforts to work with the department to get them to help fine tune and make improvements if it's too broad?
Of course.
And so I hope that's a mutual discussion.
I don't think that it was, I think it was very clearly stated that they are not interested in working or committing to work with me on this. But if they change their minds and want to provide some language that would help tailor this to make it more suitable, I would absolutely entertain that and I would bring it to the committee. That's not the message I heard, but I always stand for correction. Thank you for your question.
All right, thank you.
Okay. Any additional questions? All right. You need to read into the record. There is one proponent letter. There are no opponent letters and 0 in the neutral on LB 360. And that will close our hearing on LB 360.
See you this afternoon.
See you this afternoon. And we will reset for our next bill. All right, we're now gonna transition to LB 205. Senator Von Gillern, welcome to the Government Committee.
Good morning. Thank you. Good morning, Chairman Brewer and committee members. For the record, my name is Senator Brad Von Gillern, BRADVON, I represent District 4, which is parts of West Omaha and Elkhorn. LB 205 is the Government Neutrality and Contracting Act. The purpose of the act is to increase efficiency and reduce construction costs for government units, thus honoring our commitment to Nebraskans to steward their tax dollars responsibly. Under 805, preferential treatment language for collective bargaining units would be prohibited in requests for proposals from government contracts in the state of Nebraska. Currently, the state gives preference to project labor agreements known as PLAs. These mandated PLAs are anti-competitive and drive up the cost of construction by reducing competition and effectively excluding merit shop contractors and their skilled employees from building projects paid for by their own tax dollars. It's estimated such agreements increase construction costs by 12 to 18%, a cost borne solely by the taxpayers. Often these agreements draw temporary workers from out of state called travelers that come to work on a particular project and then move on to the next, typically not becoming a part of nor contributing to our communities. The U.S. Bureau of Labor Statistics estimated Nebraska's unionized contractors represent just 13.4% of the construction workforce. This means that when a PLA is in place, we are discriminating against 8 out of 10 workers. The shortage of skilled workers today only exacerbates the problem. A few of the online letters supporting the bill make note of this issue, including from the Nebraska chapter of the American Institute of Architects, the Nebraska chapter of the American Council of Engineering Companies, and the National Utilities Contractors of Nebraska. Recently, President Biden issued Executive Order 14063 requiring federal contracts over $35 million to be subjected to project labor agreements. So we're now squeezing Nebraska contractors from 2 directions. 18 state governors and the Associated Builders and Contractors represent 19 different organizations have responded to President Biden trying to address the federal side of this issue. At the state level, 24 other states have legislation or orders in place restricting PLAs, and Nebraska needs to do the same. I have tremendous respect for tradespeople who do the hard work in our state, regardless of their union affiliation or lack thereof. In my 40-year construction career, I worked for both union shops and merit shops and have had wonderful experiences with both. I want to make clear that passing 205 does not ban preference to union contractors nor prevent contracting with them. It simply says that the original bid process for governmental units shall be open for any and all contractors to bid, regardless of their labor affiliation. Also of note, the bill applies to all political subdivisions, state, cities, counties, schools, university, state and community colleges, who are carving out utilities such as NPPD, OPPD, and MUD with an amendment which you've now received, which is AM 231. The reason for this is that their work is highly specialized and they would like to see their workforce kept local. As stewards of public funds, we should not rig the game so that one group wins over another with no tangible benefit to and at the expense of the taxpayers. With that, I'm happy to answer any questions.
All right, thank you for that opening. Let's see if we have questions. Any questions? Senator Hunt.
Thank you, Chairman Brewer. Senator Von Gillern, do you still have any personal financial interest in a construction company?
No financial interest and no longer employed there either.
Okay, thank you.
Thank you.
Any other questions? All right, you gonna stick around close?
Yes, sir.
Good to hear. All right, thank you. Now, if you are a proponent, come on up front row. And the first one up gets to take the chair. Welcome to the Government Committee.
Good morning, everybody.
Good morning.
So my name is Katie Wilson, KATIE-WILSON, and I'm the Executive Director of the Associated General Contractors Nebraska Chapter, also known as the Highway Chapter, testifying in support of LB 205. I want to thank Senator Von Gillern for introducing this important legislation that will ensure Nebraska contractors can compete on an even playing field for public infrastructure contracts. AGC is the trade association of highway contractors who perform highway, bridge, and municipal utility infrastructure work across the state of Nebraska. My members don't build Nebraska alone, but depend on the 25,000 plus construction workers who are out daily improving Nebraska's roads and bridges. And it is those workers that bring me to this chair before you today. You might be surprised that I spend more time worrying about our workforce shortage in the highway construction industry than I do about whether Nebraska is spending enough money on their roads. In fact, AGC has been doing a lot of work in developing the workforce in the construction industry over the past 8 to 10 years. For examples, AGC Nebraska has contributed over $400,000 to date to the Central Community College Hastings Heavy Equipment Operator Technician Program. And we also award 3 $4,000 scholarships annually to students in the program. We lead an after-school construction club at a elementary school here in town, which shows 3rd, 4th, and 5th graders hands-on basic construction concepts and skills in the construction industry. Our Road Rebellion social media campaign informs teenagers and parents about career opportunities that offer 13% higher wages in the construction industry than other Nebraska jobs. And we hold an Equipment Days event during the Nebraska High School State Trap Shoot Competition in Doniphan in the spring. where we promote career opportunities to students and their families. The last 2 years, we have worked to help our members improve their HR services, which will help them recruit, retain, and train their people. Unfortunately, certain contracting practices by public bodies are only going to exacerbate the workforce shortage for the construction industry. Governments are starting to offer preferences to contractors who have a certain type of workforce. This distorts the competitive bidding marketplace and results in fewer bidders and a 12 to 18% increased cost to the taxpayer. That means we will get 12 to 18% less projects for our buck. One of the largest myths about project labor agreements is they guarantee qualified workers. This is wrong. Workforce restrictions in the agreement prohibit the contractors from utilizing their full complement of qualified employees on the project. Also, local projects that are competitively bid attract significant local bidder participation, and the bidding process is very competitive. Including project labor agreements requirements will limit local participation. I don't think that's what we want to see in our right to work state. A PLA is a working document between a public owner, county board, city council, school district, for example, and the building trade unions that dictate the terms under which the firm will run their business. It imposes provisions on management, working conditions, compensation, and unionized hiring requirements. There's tons of negative consequences, which Senator told you. I will move on. So on behalf of my members, I would urge the committee to advance LB 205 to the floor, and I'll be happy to answer any questions.
All right, let's see if we have some questions for you. Questions? Senator Redmond.
Thank you, Ms. Wilson, for coming to testify today. So how many contracts do you think your members have lost out on because of competing against PLAs?
Probably in my arena, probably not a whole lot. You would see this more probably in the vertical commercial world.
Okay.
But with the new infrastructure bill coming down, it does have language in there that promotes this type of thing. So, we're just kind of in the protection mode, so.
Yeah. And so I'm not, I'm more familiar with the county and the city process. So I don't know if in the Nebraska contracting and bidding, they have, if you are involved in a PLA or a member of a PLA or organization, that's a criteria or qualification that gets some weighted value to. And so I don't know enough about.
It would mostly be in the contract. So when you
Okay.
go to bid the job, it
Right.
would say that we're going to have a labor agreement in there, and it would have details of what the contractor would have to follow. So in our world, you're going to restrict bidders because they want to be able to hire who they can hire, so that's the downside of any kind of an agreement like that, to put in a contract. So.
And so do your members see this with great frequency in all contracts that they go out to bid for?
We
or
don't, and
no?
there are in other states. Our border states have not
Okay.
done that. They ban it in Kansas, Iowa, Missouri. So, we should probably do the same thing just to protect. We want competitive bidding. The more bidders we have, the better pricing you're going to get. So that's kind of our position on that.
Okay, thank you very much.
You bet.
All right, additional questions. Senator Hunt.
Thank you, Chairman Brewer. This type of stuff is way out of my wheelhouse. So sometimes when we get into these bills, I'm kind of like, my eyes glazing over a little bit and trying to wrap my head around this stuff. But I have a question that I'm just curious about. And maybe you can help clarify. So if project labor agreements are already in place for federal projects, aren't most roads projects then in Nebraska already a combination of like federal and state and local funds? So how would something like this work?
So they are not in place necessarily. They are recommending in the IJA, in the federal, in the Infrastructure Act. Then it goes down to the states. So the states then put their rules and regs together on that. So we have not seen that in state contracting in the highway world, but not saying down the road we won't. So this is kind of the protection mode of let's make sure that we can continue to be competitive. And that's kind of our message here is we need as many contractors bidding these projects or the prices are just going to keep increasing. So it helps, keep prices down.
Oh, thank you.
All right, any additional questions? All right, then thank you for your testimony.
You bet.
Next proponent to LB 205. Welcome to the Government Committee.
Thank you. Good morning. I am Sheila O'Connor, SHEILA, OCONNOR, Executive Director of the Associated General Contractors Nebraska Building Chapter. The Building Chapter is a trade association representing 140 commercial firms that represent thousands of managers, craft employees that build structures or buildings locally, regionally, and nationally. We support LB 205 as outlined in the purpose of the bill to provide for the efficient procurement of goods and services and to promote the economical, non-discriminatory, and efficient administration and completion of construction projects. Building chapter members believe in and are committed to open and fair competition in the pursuit of public projects. This is the best way to start any project. It will protect and allow for as many qualified bidders and pursuers as possible for governmental entities to select from for their construction projects. What would no longer be allowed under 205 would be requirements to adopt a collective bargaining agreement. We feel these decisions are best left to the contractor, employer, and their employees, and a choice should not be imposed as a condition of competing or performing for a publicly funded project. Government mandates such as PLAs or project labor agreements would no longer be allowed. These can limit competition, which typically drives up costs, can cause delays, and disrupts local collective bargaining agreements. In cases where it would benefit the project, the selected contractor would be the first to recognize the need for a PLA, and it would be the most qualified person to negotiate that PLA. In closing, we support LB 205 as it will ensure fair and open competition for everyone looking to do government contracting. We thank Senator Von Gillern for introducing the bill and to the committee for listening to its testimony today.
All right, thank you. Let's see, we have questions. Any questions? John Lowe.
Thank you, Senator Brewer, and thank you, Ms. O'Connor, for being here. So the question was asked earlier by Senator Hunt if they have seen PLAs in the line of work of the road contracting and things like that. Have you seen it in building other buildings?
I'm not familiar with it in our industry. Those conversations are between generally the contractor and the bidder. I'm not a part of those conversations.
All right, thank you.
All right, additional questions? Thank you for your testimony. We are still on proponents to LB 205. Welcome to the Government Committee.
Thank you. Good morning, Chairman Brewer, members of the Government, Military, and Veterans Affairs Committee. My name is Tony Watts McDonald, TONIWATTS-MCDONALD. I'd like to express my appreciation for allowing me to come and talk to you guys today a little bit about LB 205. I am co-owner and president of Watts Electric Company, and I'm the 2023 chair for the Nebraska South Dakota Associated Builders and Contractors Association. So I'd like to take a few minutes to explain the reasons I support and believe you should also support the Government Neutrality and Contracting Act. Previously, the feedback from Senate committee on this bill has been that it was unnecessary in Nebraska, as more than 85% of the contractors in the state are not signatory with the union. It was believed for that reason that the possibility of tactics to exclude contractors from the bidding process was minimal. However, there's now been a shift from historical practices. Over the last 2 to 3 years, PLAs, or project labor agreement language, has been increasingly present in some of the bidding and proposal documents for projects, mostly in the Lincoln and Omaha markets. While private owners are free to do as they wish with their funds, projects receiving government funding should be prohibited from including such language in their bid documents. These measures prevent 85% of contractors in Nebraska from participating in this bid process, permitting signatory contractors to inflate margins, putting a strain on project budgets. Ultimately, out-of-state union contractors would move into the area to complete the work, and Nebraska tax dollars would flow back to headquarters in other states rather than being fed back into our own economy. LB 205 would help to prevent this by maintaining fair and open competition, providing the contracting agency with the most responsible use of tax dollars. In addition, ordinances have been proposed and passed in both Lincoln and Omaha to give incentive to contractors using approved Department of Labor apprenticeship programs. I emphasize Department of Labor approved because while ABC and the unions have an approved program, a smaller Nebraska contractor would expend an immense amount of effort and incur costs to obtain this approval for their own training program to become eligible for the incentive. This provision provides an advantage to a handful of organizations and adds unnecessary costs to projects. I'm a strong believer in meritocracy, an ideology reinforced by my upbringing. By passing LB 205, government projects in Nebraska can maintain an even playing field during bidding processes to obtain the most cost-efficient solution for its taxpayers. This allows for competition and opportunity for all contractors, regardless of labor affiliation, to help build our great state. Thank you.
All right, thank you. Let's see if we have questions. All right, thank you for your time.
Thanks.
Okay, any additional proponents to LB 205? Welcome to the Government Committee.
Thank you. Good morning. My name is Ann Clutie. That's A-N-N-E, last name K-L-U-T-E. I'm the president and CEO of the Associated Builders and Contractors Nebraska South Dakota chapter. Thank you for the opportunity to be here today, and thank you, Senator Von Gillern, for introducing the bill. We are a trade association that supports the commercial construction industry, and I'm here to support LB 205. ABC has both a registered and craft training program. Our 2022-23 school year will support over 400 students through our NDOL registered apprenticeship program, our state apprenticeship program, the Nebraska Department of Correctional Services vocational life skills program, and our upskilling grants. Not only do we train apprentices in their chosen trades, but we also offer safety training for those apprentices to ensure the safety of all the individuals on all projects. Throughout our history, we have trained apprentices regardless of their labor affiliation, and we continue to offer continuing education, journeyman test prep, and safety training to any individuals in our industry. We do not discriminate in our programming and our support of the construction industry. We clearly believe that no preference should be given to any person or company, and we show that daily. We have, when a project labor agreement, or PLA, is placed on a project, it gives preference in bidding to a very small portion of the contractors in the state. PLAs force contractors to pay into retirement and other fringe programs in addition to the ones that they already have in place for their employees. The employee will never see the benefit of these, as even if the project lasts long enough for them to become vested in the program, most of the individual trades do not work on the project long enough for individuals to be vested. It costs the employer more money and hence increases project costs. Adding unnecessary costs to any project, especially in this economy, and on projects that are paid for by government dollars, hence funded by the taxes you also are constantly asked to reduce, is simply unacceptable. Let's talk for a moment about the bidding process on projects. By design, the open bidding process encourages fair and open competition, which is what every government project should do for the citizens it supports. A PLA on a government project reduces the opportunity for fair and open competition and hence reduces the number of reliable bidders on the project. As others have stated, although we do not believe PLAs are a fair process overall, this bill does not ban PLAs on any projects. It bans government mandated PLAs. Simply stated, if government mandated PLAs are on projects, they give preference to a small portion of the construction industry, and no preference should be given on any government projects. For those of you who may be questioning if there's underlying intent, this bill is not negative for union or non-union companies. It is not an anti-union bill. Union or non-union companies work together on job sites all the time. Non-union general contractors hire subcontractors, every day. Associations like ABC and AGC work every day to support the education and safety needs of the entire construction industry, regardless of labor affiliation. This bill is about fairness and open bidding processes. This is about merit-based contracting. This is about giving fair opportunity to all contractors based upon the merit of their work and the appropriateness of their bid, regardless of their labor affiliation. And I guess I'm happy to take questions now. How fast can you read, right?
Actually, you can read pretty fast. All right, questions. questions? Yes,
Yes.
Senator Rabel.
Ms. Clutie, thank you for coming to testify today. And so my question is, I'm trying to get an idea how serious this problem is. And so I asked Ms. Wilson the same question. How many contracts do your members say that they lose out on in the competitive bid process? So I can kind of get my head on how serious an issue this is.
So as Katie stated, we've not seen a lot of it in Nebraska. We're seeing it seeing PLA language slip into some of the bid processes right now, bidding contracts. However, other states have seen that it's been increasing greatly, and many contractors have bid and missed out on those. Therefore, they pass these bills. What we are trying to do is be preemptive in this and take care of this before we have an issue. We want it to be fair and continue to be fair to all contractors.
Thank you very much.
All right, additional questions? Thank you for your testimony.
Thank you.
All right, we're still on proponents for LB 205. Welcome to the Government Committee.
Thank you, Chairman Brewer and members of the committee. Thank you for the opportunity to testify in support of LB 205. My name is Brandon Ray, BRANDONRAY. I work for the Associated Builders and Contractors out of our national office. Obviously, ABC strongly supports LB 205, and we encourage members of this committee and the legislative body to do the same. By prohibiting mandated use of PLAs on public construction projects, this legislation will guarantee a level playing field in the procurement of these taxpayer-funded projects, ensuring Nebraska gets the best product at the best possible price. We've heard about the onerous provisions in project labor agreements, so I will not belabor individual things there in the interest of time. But in short, these mandates would unfairly discourage merit shop contractors and their employees who have chosen not to belong to a union from competing for projects paid for by their own tax dollars. By ending open and fair bidding, PLAs obviously decrease competition, they drive up costs, and we, as was referenced earlier, increase the cost up to 20% compared to similar non-PLA projects. The most important thing I wanted to address, as has been discussed here, is need. And as was mentioned last year, President Biden did issue an executive order mandating project labor agreements on all federal projects over $35 million in total cost. That builds on an EO by President Obama that strongly encouraged federal agencies to require PLAs on a case-by-case basis over $25 million. Additionally, and much more impactful to this state, the administration has made PLA use on federally assisted projects. These federal grant programs that provide financial opportunities to states. They've targeted certain sectors of the industry, including energy and infrastructure, various other vehicles. They've made PLAs a top priority. Guidance associated with these projects and programs all include strong encouragements to implement PLAs and or use them in the bid and grant opportunities. Some require simply disclosure of the intent to use PLAs in projects or other labor standards. A selection of these do even provide incentives in the way of percentages or points on bids if PLAs are included. As of now, only about 20% of the returned applications have subsequently included PLAs. In response to the actions by the Obama and Biden administration, currently, as mentioned, 24 states have legislation or executive orders in place restricting government-mandated PLA requirements and preferences. They've seen the writing on the wall about what these mandates do to project cost timelines and the workers that fill them. In the current environment, protecting state procurement from these mandates is crucial, and we must preserve the ability to bid their public work in a fair way to the full industry and not allow favors or preferences to find their way into the spending of tax dollars. To not be misled, this law and a commitment to fair and open competition will not preclude Nebraska or its contractors from access to any federal assistance. As mentioned, about 80% of the current proposals coming back to some of these programs we've been looking at have been free of PLAs, many coming from states that have protected their process with similar legislation to LB 205. So with that, I will be happy to answer any questions. Thank you.
All right. Thank you for that testimony. Questions? Any questions for Brandon? Senator Lowe.
Thank you, Chairman Brewer, and thank you, Mr. Ray, for being here. Where do you come from?
I come from the DC area. We work with all of our chapters across the country.
Have you seen problems with PLAs in other states?
We've seen countless problems with PLAs stemming back years, from their beginning of their use. They come down to, at the root of most of these problems, the fact that folks that have chosen not to belong to a union are either precluded from bidding on these projects in the first place, or when they do work on these projects, the benefits, the pay, all of these things that they forfeit, the rules they work under, all of these things are a problem. And then they do become a problem for the public bodies that end up mandating them on these projects with cost, availability of contractors, expertise, et cetera.
And you said that a cost of a project may increase by 20%.
Up to 20%.
Is the project any different than if a normal contractor would have done it than a union shop or whatever?
Sure. The cost, and in reference to your question, that the cost increases for two reasons. One, it is because of the decreased competition. That's just how that would work. But as you asked, there are also provisions in a lot of these PLAs that, especially to non-union contractors, would increase their costs. We're talking about double payment into their own benefit plans as well as benefit plans for the union. We're talking about union work rules where they have their workforce hired and trained the way that they do a project. Then they have to work under these additional rules, either hire additional folks or change their work processes. It takes a well-oiled machine and completely disrupts how they're supposed to do the work. So typically they stay away from it.
All right, additional questions? Thank you for your testimony.
Thank you.
All right, we are still on proponents for LB 205. Seeing none, we will transition to opponents to LB 205. And now we're going to go to those in the neutral for LB 205. I'll hold it. Okay, you're here as an opponent?
Yes.
Okay, have a seat. Welcome to the Government Committee.
Thank you for having me. My name is John Nebel, Jonnebel. I am here on behalf of the Nebraska State Council of Electrical Workers, representing over 5,000 electrical workers and their families in the state of Nebraska. I've been listening to the testimony and trying to figure out what exactly the problem is we're trying to solve. And I believe the intent of the bill is to remove the ability for a community, a government body, to define the terms to which they would like their publicly funded project to be built. And the reasons for that, I guess, are because some people don't want to be union. And fact is, this is a right to work state, so nobody has to be union. Even if you're working for a union shop, you don't have to be union. So I don't think that that's a reason to get rid of this mechanism that would allow a community to set standards, maybe some safety standards, maybe hiring local, which could be one of these standards. I think we got pretty rigid on what a PLA is, and it can really be whatever the community wants it to be. And that's what we're trying to defend here, is that any community that wants to use public funds to build something and they want to solve a extended problem with that, maybe there's a workforce shortage or there's a work shortage and they want to hire local people first before outside people are brought in. Maybe they want to hire veterans, things like that. And I guess I would say to the folks that have a problem working under terms defined by a community, it would be similar in my eyes to a Davis-Bacon project. I think we get to a point with those that we understand there's a little bit different preference there. There's a priority set, and if we can work under those, we can probably work under a PLA. And it doesn't seem to me that there's a big problem that this bill's going to fix, but it will take control out of the hands of the governmental bodies that I think the people deserve. So I would urge to indefinitely postpone this bill, and I'm available for any questions.
Okay. Thank you for your testimony. Questions for John? Yes, Senator Rebel.
Thank you, Mr. Nibble, for coming down. And you mentioned the Davis-Bacon Act. And so help me understand. So, and I'm not so familiar with Nebraska contracting processes, learning more, but aren't all public projects that are bid out required to comply with the Davis-Bacon Wage Act? Or no?
Not all, no.
Not all, okay.
But yeah, so some are, yeah.
Okay. All right, thank you.
All right, additional questions for John? All right, none. Thank you for coming up and testifying. All right, additional opponents to LB 205. welcome to the Government Committee.
Thank you. Good morning, Chair Brewer and members of the Government, Military, and Veterans Affairs Committee. My name is Susan Martin, SUSAN, representing the Nebraska State AFL-CIO and our members in opposition to LB 205. We do stand in opposition to 205 specifically because the legislation prohibits government mandated project labor agreements. A project labor agreement is a project management tool designed to ensure on time, on budget results for a given project through a streamlined labor relations policy. PLAs improve efficiency by coordinating the work of the multitude of subcontractors and craft workers engaged on specific construction projects and have been used for generations on successful public and private construction projects. The use of PLAs do not restrict competition by shutting out non-union contractors. On public projects, all contractors, union and non-union, are invited to submit bids. Non-union contractors can be found on many PLA projects. PLAs simply create a level playing field for all contractors by standardizing labor conditions on a particular project. There's a few points that I think are important to consider as you weigh this legislation. First, there's nothing in state law currently that encourages or discourages the use of project labor agreements. This means there's nothing in state law that currently encourages or discourages the use of collective bargaining labor. Second, project labor agreements may provide benefits that we feel are getting overlooked, and this legislation would do away with those benefits. Project labor agreements help to establish clear boundaries and expectations for a project, whereby a contractor and workers' established expectations lead to higher productivity, better work for better pay, as well as standardizing rules for work hours, safety, drug testing, and all others. Third, project labor agreements can be used by public project owners like school boards or city councils to set goals for creating local jobs. They may include provisions for targeted hiring and apprenticeship ratios by including the requirements for local workers to enter union apprenticeship programs. The project labor agreements can be used to help local workers gain skills, which is one of Nebraska's workforce development goals. I'm going to skip a little. To close, I just say again that the provisions of LB 205 was introduced as a means to help increase efficiency and reduce costs, when in fact we'd argue that it's not the case. Construction owners and taxpayers benefit the most because PLAs help to ensure greater efficiency on construction projects that involve many subcontractors and large numbers of craft workers from various trades. They ensure a steady flow of safe, productive, and highly trained construction labor throughout nationwide referral systems, and they establish mechanisms for avoiding and resolving disputes. Thank you for the opportunity to testify.
Wow, nicely
Right
done.
on it. Right on it.
All right, questions? Any questions? Senator Rebel.
Thank you, Ms. Martin, for coming down to testify. I mean, have you seen this to be a problem in our state of Nebraska in terms of PLAs being just as competitive as other companies and organizations, union or non-union?
Yeah, and typically, well, as far to my knowledge, the use of PLAs in the state of Nebraska has been very minimal. The only thing that I can remember that can come close was with the West Haymarket JPA and the building of the Pinnacle Bank Arena. That was an agreement. I don't think that was a PLA, but that was that type of an agreement. So
Yeah, and I do remember that. And the big emphasis on that was hiring local companies to do all the subcontract work.
Right.
So, and I guess that's considered a PLA then?
it was a I don't think it was a PLA, but it was a work agreement,
Okay.
which is what these mostly are.
Okay, thank you.
All right, any additional questions? Senator Lowe.
Thank you, and thank you, Ms. Martin, for being here. You were saying that that without PLAs, that the subcontractors may not be well organized or may not get the work done on time and everything else. Isn't that the job of the general contractor? How are we getting things done now if we aren't using PLAs now at this time?
Yeah, and I think this just ensures that that would happen. The use of a PLA would just ensure it with the general contractor and the subs and all the way around. And I'm sure there's someone behind me more qualified to answer that question if you want to bring that back up.
Thank you.
All right. Any other questions? Thank you for your testimony. Okay. Opponents to LB 205. Welcome to the Government Committee.
Thank you. Name's Ed Black, EDBLACK. I'm here for BAC Local 15. Just wanted to bring up a few points. I've heard, for one, heard ABC talking about the training that they provide. When I got into the trade, they offered no training in my field. We spend between $12,000 and $15,000 to train our employer, our members. And I know they brought up the PLAs. The PLAs just ensure that everyone gets a fair wage. That's pretty much what it boils down to. I've talked to contractors out in western Nebraska who say that they'll be happy to sign a PLA with us to get work out there. They would love to sign with us now, but it's not competitive for them out there. Well, if you get PLAs, it might help. And as for, Nebraska's a right to work state. So them saying that the PLA makes it, non-competitive, that's not true either. It doesn't say that someone has to be a union member. It's just not what it says. Pretty much fair wages is what it all comes down to.
Okay. Thank you for your testimony. So we have any questions for you? Any questions for Ed? All right. Thanks for coming in.
All right. Thank you.
Okay. Any additional opponents to LB 205? All right. If you are an opponent and you're not in the front row, please move up so we have some head count for time here. Welcome to the Government Committee.
Thank you, Senator Brewer, and members of the Government Affairs, Veteran Affairs Committee. My name is Felicia Hilton. I am the political director for the North Central States Regional Council of Carpenters.
Spell that if we could, please.
FELICIAHILTON.
Thank you.
All right, let me get my glasses on real quick. I just wanted to read what the fiscal note says from the Department of Administrative Services, State Building Division, and the Office of the Capitol Commission. That construction requests for proposals and contracts, as well as those of the Office of the Capitol Commission, do not comment on collective bargaining agreements, and no construction contract awards are influenced by collective bargaining agreements. So I think that, starting there, that no awards, at least from those state agencies, are awarded based on collective bargaining agreements is something that I think is really important. I also think that the signatory contractors that are signatory to the union, that this isn't some forced thing. This is their decision as a business model, mainly for hiring journey persons and making sure that they have a constant pool of skilled tradespeople that they can call on to perform specific work. I think that, we are in a worker shortage, but for the signatory contractors, they feel the worker shortage as well, but they also know that the labor pool that they have is a consistent labor pool that they can call on for to fill the jobs. So it isn't something that's coercive in the sense of signatory contractors. It's a choice of a business model to make sure that they always have a source of employment. And I would just say that the PLA process itself typically isn't used in RFPs and those types of things, because most of them are still lowest responsible bidder, and they're just not used very often to qualify for a bid. If you are the contractor that receives the bid, then you kind of get into what that looks like afterwards. But your initial qualification for the bid isn't, in most cases, especially in Nebraska, I haven't seen it be used in a way that would pre-qualify or automatically be used in the request for proposal, that there's a PLA or a union preference in that sense. I think that this would specifically somewhat chill that impact on signatory contractors that choose to use a business model that doesn't, that pays fairly.
All right, thank you for your testimony. We'll go to questions. Sarah Rabel.
Yes, thank you. Thank you, Ms. Hilton. And you read a statement about construction requests do not comment on collective bargaining agreement.
Mhm.
Where is that found, or how did?
That's in the fiscal note.
In the fiscal note. Okay.
Yep, in the fiscal note, and it's the fiscal note from the Department of Administrative Services, the State Building Division, and the Office of Capital Commission, which would typically do all of the public letting for a lot of the vertical construction.
Okay. And so that's a statement that's posted clearly
Yeah,
on their website, or?
No, it's on the fiscal note of the bill.
Fiscal note.
Yeah,
Okay.
of the bill. And they basically just say that, no construction contract awards are influenced by collective bargaining agreements. And I just think that that's the crux of what we're talking about, is that most public contracts or public owners don't use that as to influence whether or not someone gets the bid. It's usually the price and the cost. And I just would like to add that most of the material costs are the same for any construction project. So if it were to be less, it's on the backs of workers. And that's the only real contention that I have with what the proponents were saying about the bill, is that somehow it costs more. Well, it doesn't really cost more than any other project unless you're willing to pay workers less to do a very dangerous job with the skills that they've been trained in the union's cases, trained to do. And there's a number of contractors that are non-union that do great work, pay their workers well. So this isn't, in our opinion, this isn't about, this is just about legitimate contractors bidding public work, and whoever gets the bid, they've received the bid. And I don't believe there's any influence on whether or not they're union or not. I don't think most government engineering departments or whoever would let these bids know every contractor that's union or non-union. I just don't think that they would know that. They just look at the bid.
Okay. Thank you very much.
All right, any other questions? Thank you for your testimony. All right, additional opponents. Welcome to the Government Committee.
Good morning, Chairman Brewer and committee members. I am in Nebraska, right?
Yes, you are.
Just wanted to make sure. My name's Ron Kaminsky. I am born and raised here in Nebraska. I'm the president of the Nebraska Building and Construction Trades Council. We represent over 2,000 contractors that do work in the state of Nebraska and over 20,000 construction workers, and growing by the day. First of all, PLAs, since I've been in the construction industry for 25 years in Nebraska, have never been used in the state of Nebraska. Ms. Martin, who testified previously, stated about the arena down here in Lincoln. The arena that was built down here in Lincoln was an out-of-state contractor was chosen. That contractor was trying to bring workers in from Minnesota. We talked with the mayor. Part of their promise to the city of Lincoln was to provide local jobs for local workers, and they struck out right off the bat. Project labor agreements ensure that local workers are used first before out-of-state workers. We've talked about interstate commerce. Here, we've talked about ways to ensure that local workers are hired for projects. And the best way to ensure that local residents from Nebraska are hired to construct projects is to ensure that they're under a collective bargaining agreement, or hopefully someday maybe a project labor agreement in the state of Nebraska. This is another case of big government coming in, trying to pass stuff out of Washington, D.C. that does not affect companies here, has not hurt companies here. We have companies that are part of AGC also that are in favor of project labor agreements. Nebraska is a right-to-work state, meaning you do not have to be a union member to even work under a PLA. This just seems like politics at its worst again. And the only thing that this is going to do is to ensure that workers aren't protected on a job site. Do we want Nebraska workers to do the best they can do? Absolutely. This is going to ensure that training of workers is less, as we spend millions of dollars on Nebraska residents every year, ensuring that we have successful apprenticeship programs, and we train workers not to make starvation wages, but to make wages so they can be good tax-paying residents of our state. It's very unfortunate that we hear all these positive things that AGC is doing. We do all those things times 20. Okay, we provide scholarships every year. We send thousands of people through apprenticeship programs. We do all that stuff. This is another case, like I said, of big government coming in, and this is going to cause more issues for contractors in the state of Nebraska than to help them. So I'd be happy to take any questions that anyone has.
Okay, thank you. Questions? All right, thank you for your testimony.
All right, thank you.
All right, no additional proponents. Is there anybody here in the neutral? Then we will invite Senator Von Gillern back up for closure. Just for the record, on LB 205, we have 9 proponents, 3 opponents, and none in the neutral position. You may close.
Thank you, Chairman Brewer. I've been scratching notes fast and furious, and I don't want to keep you. I know you got another bill behind me, and then lunch in the afternoon, so I don't want to keep you too late. But I do want to address some comments that were made. PLAs have been used in Nebraska. Again, I've sponsored some bills here and spoken in hearings for the past 2 weeks on some things that I was not as well informed on as maybe some other experts that followed me in testimony on certain issues. This is one I know. It's one I've seen. This has been my life's work for the past 40 years. PLAs have been used in Nebraska. They've been used at Offutt, primarily on federal funded projects. Metro Community College dipped their toe in this a number of years ago, and the city of Omaha has. Now, what's unique, or what you need to understand, is that sometimes the PLA will not be written because obviously the folks that are motivated to go in that direction, they'll write the PLA, or they'll write the bid agreements in such a way where they will pick out specific elements of requirements that are unique only to contractors that are union affiliated. And that might be a certain benefit program, or it might be a certain training program. It would not necessarily be numbers of hours or certifications or anything else, but there are ways, as we all know as legislators, there are ways to write certain agreements to get what you want without saying what it is actually that you want. So some of them, frankly, are a little bit sneaky about how they get it done. The question, Senator Raybould, you asked some great questions. How many times has this been seen? How many times has it been done? And obviously the fiscal note can't measure anything because it typically has not been done, but this absolutely is the direction that things are moving across the country. And we have lots of laws in place. We have lots of procurement policies in place for things that don't happen every day that we don't want to see happen. And this is one that we certainly don't want to see happen because, again, we're charged with the fiduciary responsibility of handling the finances of the taxpayers. A couple of specific things I want to address. If you do look at the fiscal note, and I won't drag you there right now, the language that is addressed in the fiscal note basically says you cannot coerce a contractor to become a part of a collective bargaining unit. It does not say that you can't contract with, the state statute says that you can't contract in that direction. So I encourage you to dig into that a little bit more deeply. One of the opponents testified about projects getting done on time. I have yet to see a merit shop contractor go on strike. I've seen substantial project delays on contracts or on projects where union contractors have gone on strike and it's impacted the completion dates. So I would contest that claim also. And then lastly, the emphasis on local, buying local, keeping local, and so on. And I made a comment in my opening testimony about travelers. When union contractors hit their maximum or hit their capacity for available workers in the local area, they bring in travelers from out of state. Typically, those are not folks that are able to, for whatever reason, find work in their own jurisdiction, in their own trade hall. Typically, they're not the cream of the crop, to be quite frank. So we have folks that come in from out of state, and they're not the best workers in their trades. They don't stay here. They come and they go, and typically their tenure is not nearly as long as those workers that are working for merit shop contractors. They don't invest in the community, and they don't become a part of the community. So again, I want to wrap up, which I know you'll all be thankful for. Again, I started off my testimony on this, and I want to end it the same way. This is about fiscal responsibility, and it's about stewarding the taxpayers' dollars and doing the best things that we can for the taxpayers. With that, I'll wrap up and take any questions.
All right. Thank you for your testimony or your close. See if we got any questions. Questions. All right. Thank you for your.
All right. Thank you.
You got it. All right. We'll quickly reset for our next bill. All right, if you are a proponent for LB 343, you want to move forward so that we know who we got. And then as soon as we get through the proponents, we'd ask everyone who's an opponent to shift forward. That way we speed up the process here because we may be close on time. All right, we will go ahead and get started on LB 343. Senator Slama, welcome to the Government Committee.
Thank you. Set up here. Good. Not quite afternoon yet, morning still. Chairman Brewer and members of the Government, Military, and Veterans Affairs Committee. My name is Julie Slama, Julie-SLA-MA, and I represent District 1 in Southeast Nebraska. I'm here today to introduce LB 343, which would adopt the Anti-Discrimination Against Israel Act. The boycott, divestment, and sanctions movement aims to undermine Israel's political and economic stability. The main objective of the BDS movement is to economically destroy the state of Israel by gradually discrediting the Jewish nation until the international community is persuaded that Israel has no right to exist or defend itself against its adversaries. In recent years, there have been attempts to pass legislation in various states and at the federal level to oppose the BDS movement and support Israel. These efforts have taken on various forms, and to date, 34 states have adopted laws, executive orders, or resolutions designed to discourage boycotts against Israel, as you can tell from your map that I just handed out. This includes our neighbors of Iowa, South Dakota, Kansas, and Colorado, and more recently, Idaho, Utah, and West Virginia. These laws have been put in place across the country to protect state taxpayers from supporting discriminatory boycotts against Israel. The legislation before this committee makes a simple proclamation that if an entity wishes to enter into a contract with the state of Nebraska, it must agree and certify in writing that it will not engage in or is not currently engaged in a commercial boycott of Israel. This law would only apply to contract values higher than $100,000 or to contractors who have 10 or more employees. To be clear, this law would not infringe on anybody's individual rights to boycott or otherwise be anti-Israel. Additionally, this does not obligate institutions to invest in Israel. This law would simply ensure that we as a state government are not complicit in efforts to harm a key partner for both the United States and Nebraska. It is entirely permissible for a state to conclude that a corporation boycotting Israel prioritizes politics above business interests in a way that reduces the effectiveness of the company and impairs contract performance. Such a conclusion is entirely within the lawful purview of legislative discretion, as held by the Eighth Circuit by upholding the same language we're presenting to you today in Arkansas. The government of Nebraska has a strong relationship with the state of Israel, both through person-to-person connections and an economic relationship that saw over $40 million in exports to Israel in 2021. Furthermore, since 1996, Nebraska's exports to Israel have totaled more than $603 million, and Israel now ranks as Nebraska's 26th leading trading partner. Israel is certainly a place where potential business and trade partnerships can be found. By enacting this legislation, not only do we ensure Nebraska is on par with the overwhelming majority of other states, but we would be protecting our growing economic ties with Israel, shining a light on those who seek to do it harm, and ensuring our taxpayer dollars are spent in a manner that reflects Nebraskan values. With this said, companies who may seek to do business with the state of Nebraska should be on notice that we and at least 34 other states will not help fill your coffers if you attack and seek to delegitimize our friend in Israel. Let us strengthen the relationship between Nebraska and Israel and advance the Anti-Discrimination Against Israel Act today. People and businesses are free to do business as they see fit, but it's up to the Nebraska legislature to respond as they see fit as well. I'd encourage you to stand with me and support LB 343. I'd be happy to answer any questions you may have, though there are experts behind me who could probably testify in greater detail.
All right, thank you for that opening. Questions for Senator Slama? Senator Lowe.
Thank you. It appears that there are 35 states that have already passed this legislation and 15 who have not or are on the way to passing it.
Actually, if you reference the map, I don't know if it's clearly marked or not, but the states that are solid on your map, so that's 34 states, have passed similar legislation, if not the same language. The ones that are striped have had it be proposed. So that's an additional 13 states for a total of 47. So, yep.
Thank you.
Thank you.
Okay, additional questions? Senator Hunt.
Thanks, Chairman Brewer. You said that it's 34 states that have passed the legislation.
Yes, ma'am.
Or executive order or resolution.
Yes, ma'am.
So not necessarily a law, but potentially like an executive order or resolution.
That has the force of law, yeah.
Okay.
Yep.
Why not have an executive order in Nebraska instead of legislation?
Because I believe in the strength of the legislative branch, and I don't think the executive should be legislating from his or her office.
Have you had any conversations with the governor about about his support of this legislation or a potential resolution?
I have not. For me personally, again, I think the legislative route is the best way under my belief in federalism to go in terms of letting the legislative branch legislate.
Okay, thank you.
Thank you.
All right, Senator Holler.
Thank you, Chairman Brewer. Thanks for bringing this bill, Senator Slama. So a company would be required to have a written certification that they are not conducting a boycott on Israel to do business with them.
Yes.
What if they sign that agreement certification and then we find out later that they are boycotting?
We've got representatives from DAS here who can run everybody through the legal repercussions of them going against their contractual obligations on that front.
I do the same thing. I pass it off to someone smarter than
Same.
me anyway, but not you. Thank you.
All right, Senator Rabel.
Thank you, Senator Slama. And I'm sorry, I missed part of your opening
gosh, no
remarks.
worries.
So I apologize if you addressed this already. But I'm kind of curious, in your research, how many Nebraska companies currently have a boycott against the state of Israel?
Well, thankfully, I believe Nebraska's been very proactive in our approach to contracting. And again, Director Jackson can speak more specifically to this. And I think it's important here to reference the Eighth Circuit's holding of the same language that we're proposing today in Arkansas, in that a company can choose not to do business with Israel if it doesn't want to. I mean, I'm not actively doing so, but I'm not actively boycotting Israel either. The language of this bill makes it clear that you have to be in a public boycott of Israel. And I think Director Jackson can speak a little bit more to the details of how that applies to Nebraska, but the court's holding was really important just in the applicability of this case in Nebraska and ensuring that our businesses are still free to do business as they see fit.
Okay, and so, Director Jackson will talk about the numbers, and I guess, I mean.
Absolutely.
You have to publicly register that you're boycotting?
No,
Or
how
does that work?
How it typically works in the contracting process in other states that have it, among other forms that any business doing business with the state have to sign. There's a large series of these. One form would be a simple certification that I'm not actively, nor do I intend to, nor will I be, engaging in a public boycott of Israel as part of the BDS movement. It's a form that's been put together by other states and used and has been held up in court several times.
Okay, but to the best of your knowledge, you are not personally aware of companies in Nebraska that are currently boycotting the state of Israel?
If you asked me to rattle off the names of those companies, I would not be able to, and I could not testify to a specific number.
Okay,
so
thank you so much.
Yeah, I mean, we've got thousands of contracts in the state of Nebraska, so I would hesitate to speak on that one from my personal perspective.
All right, any additional questions for Senator Slama? All right, you'll stick around for close?
Of course.
All right, thank you. All right, we're going to start with proponents to LB 343. Welcome to the Government Committee.
Thank you. My name is John Myers. I'm from Auburn, Nebraska, JOHNMYERS. I'm here today in support of LB 343. This legislation is similar, as already been explained, to that which had been adopted by a number of states. I would like to point out that this is not a conservative or liberal question, since the states include Colorado, Illinois, Florida, Iowa, New York, California, Kansas, and South Dakota. It's a wide variety of political views. Support for the BDS movement, which this legislation targets, is applied against only one country, Israel. No other country, regardless of their human rights record, is targeted. BDS advocates distort issues surrounding the Palestinian areas in Israel in an effort to persuade organizations from doing business in Israel. Interestingly, with the advent of the Abraham Accords, the United Arab Emirates, Bahrain, Sudan, and Morocco have begun both economic and security agreements with Israel. If proponents were correct in their assessment that Israel was trampling the civil and religious right of Palestinians, I believe that it's unlikely these agreements would have come to fruition. Thus, I can only conclude that proponent support for BDS and opposition to Israel has less to do with civil and religious rights and more to do with an agenda against Israel. Since this is a political issue, citizens of Nebraska should not enable and support by our tax dollars organizations which are engaging in actions detrimental to our close ally and the only true democracy in the Middle East. This legislation does not prevent an organization from engaging in a boycott, but it ensures that Nebraska government is not supporting such a boycott of our friend and ally. Thank you for allowing me to address my support for this legislation.
All right, thank you for coming in and testify. Let's see if we have questions for you. Any questions? All right, thank you, John. Okay, next proponent. for LB 343. Welcome back to the Government Committee.
Thank you, Colonel. Morning, Colonel Brewer and members of the committee. My name is Jason Jackson, Jason, Jackson. And I'm the Director of the Department of Administrative Services, and I'm here to testify in support of LB 343. Administrative Services and our State Purchasing Bureau oversee our procurement process for state government. And we have an interest in making sure that when we make purchasing decisions on behalf of the state, that we're not acting in an adverse way to America's foreign policy interests. The State Department has identified Israel as one of America's greatest friends. They further have said that Israel's security is part of our longstanding security interests. And Israel has been identified as a non-NATO major U.S. ally. And so when we observe companies attempting to bring negative coercive economic pressure against one of our primary allies, that's obviously at odds with our foreign policy interests. And from the state's perspective, we don't want to be supporting that type of activity. From an implementation perspective and an administrative perspective, again, there are states that have gone before us. If the legislature were to enact this law, it would bring us into alignment with more than 30 other states that have preceded us. From an implementation perspective, this would be a relatively easy bill to administer, and we don't anticipate any difficulty in working with our sister agencies to bring them into compliance with the law. With that, I'd be happy to answer any questions you may have.
All right. Well, thank you for your testimony. So we have questions. Senator Holler.
Thank you, Mr. Jackson, for
Yes,
being
sir.
here today. I'll ask you the same question I asked Senator Slama. If a company signs the agreement that they're not boycotting Israel, and I would guess that you review that company closely to determine that, but what if it slips through the cracks and in fact later we find out that they were boycotting, but we have a contract with them? What actions are taken?
Yeah, I think the bill contemplates that if enacted, DAS would administer policies or regulations to bring the bill into effect. What we would do is benchmark with some of the states that have preceded us here and try to identify what are some of the leading contractual remedies that they've employed that would hopefully, represent the will of the legislature, but also not pose a business disruption to, any agency for a critical service. So, yeah.
All right, thank you.
Yep.
All right. Additional questions? Yes, Senator Hunt.
Thank you. Chairman Brewer, did you speak to if any Nebraska companies are boycotting Israel or part of the BDS movement that you know of?
Yeah. So thank you to the question.
Sorry.
Yeah, no. Thanks for the question. And if I may, I intended to do this in response to the first question, but I forgot. I also just want to share with the committee, it's not germane to this bill, but I was concerned about the private company that testified on the preceding bill with respect to their issue with DHHS. Our general procurement process is that we try to know a company's renewal status 6 months in advance to exactly prohibit or prevent that type of circumstance. And so my team is following up with that individual to figure out exactly what went wrong there and hopefully take corrective action. Senator Hunt, with respect to your question, I'm not aware of any companies, but we also haven't proactively done this work. We did see that some other states that have preceded us have created repositories or lists of companies that they've identified that are participants, but I'm not personally aware of any.
Well, the famous one is Ben & Jerry's, which is owned by Unilever. And so if this bill were to pass, would Ben & Jerry's then go on some list saying we're not going to contract with Ben & Jerry's, or how would that be implemented?
I wasn't aware of Ben & Jerry's.
Okay. Well, it's a really famous case. So,
Okay.
Anyone who's followed this knows that. For
I
sure.
think generally our intention would be to apply this prospectively. Where we've seen it done successfully in other states is basically, the company certifies as part of the procurement process that they're a non-participant. That would be kind of a part of the specs or criteria for the evaluation of the bill or the evaluation of the bid. and a representation on the part of the company that they were participating in the movement would disqualify them from doing business in the state. There's not an intention, again, we would want to comply with whatever the will of the legislature is on this, but as we read the bill, it doesn't really operate prospectively, or I'm sorry, retrospectively with any existing contractors.
I'm good.
Any more questions? You're good?
Thanks.
Okay, any other questions? Thank you for testifying.
Thank you, sir. Thank you.
Okay, we are still on proponents to LB 343. Come on up. Welcome to the Government Committee.
Thank you, Senator Brewer, and the rest of the committee here. I am Alice Myers, ALICEMYERS. And I'm going at a little different perspective. I support the Legislature Bill 343. The BDS movement has never helped any Palestinian, nor will it ever. Instead, it has served to drive a deeper wedge between Israelis and Palestinians by perpetuating the conflict. Pro-BDS organizations like Students for Justice in Palestine support a Palestinian state from the river to the sea, calling for the elimination of this Jewish state. Disguising its destructive intention as concern for human rights, the BDS movement ignores real human rights abuses in Palestinian-controlled territories and throughout the Middle East. Moreover, BDS advocates turn a blind eye to the way their movement harms Palestinians and Israelis alike by using rhetoric like genocide, oppression, and apartheid. The BDS movement creates a threatening political environment in which all who desire justice must support BDS. For example, thousands of Palestinians work in Israel with work permits to provide for their families in the West Bank. BDS threatens these families' security and source of income. Likewise, numerous Palestinians find employment working alongside Israelis and communities in Judea and Samaria. Consequently, boycotting disputed territories under Israel's control harms both Israelis and Palestinians and diminishes the positive on-the-ground interactions these two peoples have when working side by side. Putting another way, boycotting Israel and its territories is not pro-Palestinian, it's anti-peace and anti-humanitarian.
You're complete? Okay, thank you. All right, questions for Alice? All right, thank you for testifying. Okay, next proponent for LB 343. All right, we will now switch over to opponents. Proponent. Oh, you're a proponent?
Yes.
All right, come on up. Welcome to the Government Committee.
Thank you, Chairman Brewer. My name is Colin Bonney. I'm the president of the TPUSA chapter at UNL. Just right off the bat.
Spell that. So.
Oh, COLLIN. That's with two L's. I want to say my views don't reflect the views of the
Last name and first name.
Oh, COLLIN BONNIE.
Thank you.
Yeah. My views don't reflect the views of the organization. I'm just here on behalf of myself. I just kind of want to go through a history lesson here. According to the U.S. Embassy, the U.S. was the first country to recognize Israel on May 14th, 1948, under Harry Truman. Diplomatic relations were established on March 28th, 1949, and they have been our eyes and ears in the Middle East and the single largest trading partner of the United States. And so, even though they've been our most consistent and valuable ally, there are still some that publicly oppose Israel. I have no idea why that could be. Could be fueled by rising anti-Semitism that I've personally seen firsthand. Part of that could be because of the BDS movement, or maybe it's just because of corporate pandering. Regardless, at the end of the day, I'm a huge proponent of the First Amendment. Companies have the right to protest who they want to protest. And even if I disagree, that's their decision. However, I believe that Nebraska also has the right to decide who they want to support. And I believe in the passing of this bill will reflect the majority of the views in Nebraska. And with that, I yield my time.
All right. Thank you. Questions? All right. Thank you for taking the time to come in. All right. We're still on proponents. Welcome to the government committee.
Thank you. My name is Gary Javich, G-A-R-Y-J-A-V-I-T like Tom, C-H, and I'm from Omaha. It's my honor to be a co-representative of the Jewish Federation of Omaha before you today about this bill to prevent any company or public entities that boycott Israel from doing business with Nebraska. 3 points. 1, this bill addresses a direct threat to Israel, one of our country's most loyal allies and its best ally in the Middle East. While not specifically named, the menace this bill addresses is the boycott, divestment, and sanctions movement known by its initials BDS. BDS seeks ultimately the destruction of the world's only Jewish state by demonizing it, delegitimizing it, and holding it to a double standard to which no other country must adhere. And why should Nebraskans care about this country thousands of miles distant? Point 2, self-interest. And that's a compelling reason. At the national level, the U.S. and Israel share important technology in areas of medicine, science, agriculture, cybersecurity, and military defense. At the state level, you should know that in 2020, Nebraska exported over $50 million worth of manufacturing goods to Israel. And since 1996, the value of Nebraska's exports are more than $560 million, ranking Israel as Nebraska's 20th leading trade partner. More than 30 Nebraska companies have discovered the benefits of doing business in Israel, including UNL. Besides our business and academic connections, Israel is also a major tourist attraction to many Nebraskans eager to see the Holy Lands where all faiths get to practice their religious traditions. Our ally and trading partner shares our moral, cultural, and traditional values. And I emphasize, of all the countries in the Middle East, North Africa, the Jewish state remains the only country in that area to permit free speech, free religion. Point 3, the concern over free speech rights. A legal scholar pointed out that this law, anti-BDS laws, do not infringe on speech. They don't regulate speech at all. Free speech and commercial rights are two different things. In 2022, the full Eighth Circuit U.S. Court of Appeals ruled that boycotts are not protected by free speech. Free speech aside, as a sovereign state, Nebraska can certainly decide who they would do business with. And for all these reasons, this anti-discrimination law requiring a pledge to not boycott Israel deserves passage. Questions?
Thank you. Let's see if we have questions for you. Questions? All right. Thank you for coming in. Oh, I'm sorry.
Thank you, Chairman Brewer. I would like to hear your view about a question I asked earlier.
I'm sorry, you'd like to what?
I'd like to hear your views on a question that I asked earlier.
Yes, well, I'm not aware, and I don't think anybody else is, of a company that's currently boycotting Israel, but the ever-increasing threat from the BDS movement is of major concern. On college campuses across the United States, the BDS movement is gaining a foothold, as is the rise of anti-Semitism across campuses on the United States. And we all know that a portion of our Congress to the very, very far left and I'm pointing out it's the very, very far left, is very anti-Israel. So we have to anticipate, and that's why this law, this bill has value.
What I'll ask you is, to you, is a boycott the same as discrimination?
I think by definition it is.
Okay, thank you.
All right, any other questions? All right, thank you.
Thank you
for your time. And we will move to the next proponent to LB 343. Welcome to the Government Committee.
Thank you, Senator. Good morning. My name is Sharon Brodkey, SharonBrodkey. I am the Executive Director of the Jewish Community Relations Council of the Jewish Federation of Omaha. I am here to urge you to vote in support of Legislative Bill 343 that prohibits state contracts with companies that boycott Israel. This bill accomplishes 4 things. It protects the financial interests of Nebraska citizens by ensuring that the state invests in funds and contracts are shielded from the economic damage and instability caused by parties that engage in discriminatory boycotts against businesses operating in Israel. Number 2, it protects the social interests of Nebraska citizens, ensuring that your and my tax dollars are not party to discriminatory contracts and investments. Number 3, it aligns Nebraska with 35 states that have already passed similar legislation or executive orders. And finally, number 4, it aligns Nebraska with the federal government, which rejects boycotts based on national origin and interferences with foreign trade policy in general. It's important to note that courts have already determined that these policies do not violate First Amendment rights. Economic boycotts are not protected speech, but are instead a form of commercial activity. LB 343 is limited, does not prohibit individual boycotts of Israel, as you've already heard, or penalize anti-Israel speech. Individuals remain free to call for, participate in, and encourage others to join in boycotts against Israel. But let's be clear. The commercial boycotts addressed in this bill are a form of national origin discrimination driven by bigotry and hate. The international BDS movement at its core is anti-Semitic and does nothing to promote peace. Instead, it seeks to cancel Israel. Its campaigns represent a hostile delegitimization tactic that rests on a fundamental rejection of Israel's right to exist. BDS co-founder Omar Barghouti even said, "Most definitely we oppose a Jewish state in any part of Israel's internationally recognized borders." The Palestinian and Israeli economies are intrinsically linked, and a boycott of Israel damages economic opportunities for both parties. BDS initiatives sever the economic ties between Israel and its Palestinian neighbors. This is not a good path toward a long-term lasting peace. LB 343 does not attempt to legislate how people feel or think. Unfortunately, anti-Semitism and Israel haters will always be around. LB 343 simply says that the state of Nebraska will not use our tax dollars to support hatred. Nebraska says no to a movement that is harmful to the long-term security and economic viability of both Israelis and Palestinians. Perhaps the best service I can provide in conclusion is to articulate this point in practical terms so Nebraskans can appreciate the public policy protections our state is considering here today. BDS traffics in discrimination, which directly contradicts our federal government, our state government, and our Nebraska values. This law provides Nebraska's private sector with a clear business rationale for avoiding discriminatory practices and boycotts. So I urge you to vote on the right side of this issue. Vote for LB 343 and against anti-Semitism, discrimination, and divisiveness. Thank you for your time.
Okay, questions? Questions? All right, thank you for your testimony.
Thank you.
We still are on proponents of LB 343. Welcome to the Government Committee.
Thank you. My name is Jake Bennett, Jakebennett. I'm Director of Policy and Legislative Affairs at the Israeli-American Coalition for Action. And since this is Government and Veteran Affairs, I'll say I'm also a veteran of the Golani Infantry Brigade of the Israeli Defense Forces, and pleased to be with you here today. First, to solve any concerns that might be out there about Ben & Jerry's and Chunky Monkey and Jerry Garcia. Unilever has reversed the boycott of Israel as of a couple months ago. So your ice cream supply is not going to be in contention here with this bill. So that's good news. There's been a lot of talk about the effect of this protecting America's relation with its foreign trade partner. I just want to stress also that there's an impact here for local businesses in protecting them against the coercive methods of the BDS hate movement, which tries to coerce local businesses to boycott Israeli-owned businesses. In addition, it tries to boycott anyone operating locally who has a national origin connection to Israel. So Jewish or Israeli Americans also get targeted. So there's a local discrimination element here as well as the targeting of Israeli-owned businesses. So I do want to provide a clear explanation just to dive a little deeper into what the bill does not do. So according to the U.S. 8th Judicial Circuit, which Nebraska is a part of, in June 2022, the 8th Circuit decisively ruled that the law Nebraska is creating here does not regulate private conduct of free speech. In a very practically worded opinion that's worth reading, the Arkansas court clearly explained that these laws properly regulate the conduct of commercial activity. The pro-Israel community fully supports the First Amendment of the Constitution, and in this case, states have created laws that carefully regulate commercial activity and not the conduct of free speech. Anti-BDS laws are narrowly tailored anti-discrimination laws, similar to many other anti-discrimination laws that protect, among other categories of people, women, racial minorities, LGBTQ individuals. All of these laws help highlight the critical distinction between commercial activity and the exercise of free speech, which comes into sharp focus in the course of carrying out the government's obligation to protect various classes of people from discrimination. In closing, in passing Nebraska's law defending the state from anti-Israel commercial boycotts, this legislature is being perfectly clear in its intent, predicating its passage on the recognition that such boycotts are overwhelmingly anti-Semitic in nature and not political. That's why these laws have passed with such a high level of co-sponsorship and bipartisan support in all instances. It's critical at this point, once again, be re-emphasized for the benefit of the public and the onlooking courts that may need to further take this point into account. In conclusion, I congratulate the people and government of Nebraska for taking this stand and working on this bill.
All right, thank you. Questions? Questions? All right, well, thank you for your service to Israel and
thank you, Colonel.
Thanks for your testimony.
Thank you.
All right. Next proponent, LB 343. And you're going to see some folks moving because the exec board is going to start and we have a member on the exec board that's here and I am the first presenter in the exec board. So don't panic. It's just kind of the shuffle we got to do to take care of all the committees. And when we have long days, they overlap. So with that, please, sir.
Thank you, Chairman Brewer and committee. My name is Gene Alphin, Genealphin. I'm the pastor of the Life Church here in Lincoln, Nebraska. Listening, well, when I had my voice, obviously, to support of LB 343, listening to all these comments, I feel like I have almost nothing to add. But as a preacher, I can always find something to add. I have a unique perspective that I just returned from Israel. I stood on the border with Lebanon, stood on the border with Syria, stood at the very gates of the Gaza Strip, and talked with people from all walks of life, from rabbis to family members to a man from the media, the Jerusalem Post, that was an Israeli Arab living there in Israel, come away with a unique perspective that what we probably most of us know is Israel has been hated for who they are from the very beginning of recorded history. And we live in a society that's trying to do away with bigotry. It's the most worthy fight that we have to fight today. And I want to call on this committee and this state to take a stand. There's been questions asked of, well, who do we know that actually does this violate or would be in violation of this? I don't know that even matters if we have nobody in violation of this. I think we need to make a stand in support of our only ally true ally that we have in the Middle East, and the most stable government, if not the only stable government that we have there. These boycott, BDS, or excuse me, these BDS movements are based in hatred. And I think not only does the world, and hopefully the United States, but definitely this great state, we've had enough of that kind of stuff, and we need to stand up in support of this great nation. And those are my comments.
All right, thank you for those. See if we got questions. All right, thank you for your testimony. Okay, we are still on proponents to LB 343. All right, we'll now transition to opponents to LB 343. Welcome to the Government Committee.
Thanks. Okay. Good morning. Good morning, committee members. My name is Alexia Plummer. That is ALEXZIA Plummer, PLUMMER. I'm here today as a private citizen, and I oppose LB 343 for 3 reasons. 1, it does not materially benefit the residents of Nebraska. 2, it curtails commercial speech and the political expression of businesses. And 3, it sets a dangerous precedent. 1, this bill does not benefit Nebraska residents. I can think of no meaningful ways that Nebraskans' lives will improve because the state won't give contracts to companies boycotting Israel. It is solving a problem that doesn't exist in our state. The idea that residents look to government contracts as endorsements of ideology doesn't make sense. They're more concerned if the company is using their funds appropriately. Number 2, the bill seeks to limit commercial speech. I can think of no other instance where a business has to pledge a loyalty oath to a particular political stance in order to do business in the state. Similar laws are being challenged in other states. It's been brought up a few times in the Arkansas case, Arkansas Times LP versus Waldrop. The ACLU has filed a petition with the U.S. Supreme Court, urging the court to review a decision from the U.S. Court of Appeals for the 8th Circuit. Here's a quote from one of the amicus briefs, this one by First Amendment scholars supporting the petitioner. From the Boston Tea Party to the Montgomery bus boycott to the campaign for divestment from apartheid South Africa, boycotts have played a central role in this nation's history. Americans have used boycotts across a range of issues to express their shared convictions. As to the specific boycott of Israel, I think it is being mischaracterized as discrimination against all Jewish people. I can appreciate the desire to stop the rising tide of anti-Semitism, which is very disturbing, but the boycott, divest, and sanction movement is not about action against a Jewish state, but instead against a state that is perpetuating human rights abuses against its Palestinian residents, including not having the freedom of movement. In the same way that boycotts of South Africa in the 80s and 90s was not against a Christian nation, but an apartheid nation. Boycotts are a powerful way to use the markets to make political statements. Third, I'm afraid that if this passes, it'll set a dangerous precedent. It demands a loyalty oath when a company not only cannot boycott Israel, but cannot do business with any other companies that boycott Israel. And what other instance is awarding government contracts based on political ideology? My fear is that it will lead to other loyalty oaths that will just be under the influence of whoever is in power in the state at that time. And this is, to me, is government overreach. In conclusion, this does not solve a problem that we currently have. It limits commercial speech, and it could possibly lead down a slippery slope for other government overreach. Thank you for your time.
Thank you. Do you have questions? Questions? All right, thank you for your testimony. Okay, next opponent to LB 343.
I'll go first.
Okay. Welcome. Okay, we are on opponents to LB 343. There we go. Thank you. Welcome to the Government Committee.
Thank you. My name is Sarah, S-A-R-A, Paul, P-A-H-L, Ramirez, R-A-M-I-R-E-Z. I'm a retired public health nurse and I live in Omaha. And I speak in opposition mostly on First Amendment grounds. And I know you senators know this, but I have to say it. The First Amendment of the U.S. Constitution states in part that Congress shall make no law abridging the freedom of speech. In 1982, the U.S. Supreme Court established that politically motivated consumer boycotts are fully protected by the First Amendment as free speech. LB 343 says on page 2, line 29, a public entity shall not enter into any contract with a company for goods or services unless the contract includes a written certification that the company does not currently engage in and agrees for the term of the contract not to engage in a boycott of Israel. I find this problematic. First, what is the advantage to the state of Nebraska in passing such a law? If we're doing 50 million in exports now, we'll probably be doing 50 million in exports next year too. How do the people of Nebraska benefit with a repressive loyalty oath required? And the result will be to increase paperwork, increase the expense in business, and increase the time spent to do business. Classic red tape. Second, I beg to differ with the previous speaker. It does impinge on the exercise of free speech. One of the speakers before mentioned that it's a coercive action. Well, it was pretty coercive to dump an entire cargo of tea into the Boston Harbor. But I think there are very few Americans who would think that should not have been done. And Senator Slama, that is you, right? I could not hear you clearly from behind, even with the hearing aid. But I believe you mentioned the Eighth Circuit opinion. I know several of the proponents did. Okay, talk to you, sorry. They used some pretty tortured reasoning to get to that opinion. And just dividing the boycott from the purchasing decisions behind it, I think that's pretty tortured. And I am sure there is going to be challenges reaching the U.S. Supreme Court to clear this up. 3 minutes?
Thank you. Yes. Thank you for your testimony.
Please do not pass this bill. out of
Questions?
committee.
Okay. Next testifier. All right, and those of us that need to be in the exec board, it is time to move out. In the yellow over.
Give it just a minute.
Sure.
Welcome to the Government Committee.
Thank you. Oops, wrong side. Good morning, Chairman Brewer and Senator Sanders and committee. My name is Cynthia Ruby, C-Y-N-T-H-I-A, H-R-U-B-Y. I am here to oppose LB 343, just as I did LB 845. My opposition is based on U.S. government's unwillingness to put pressure on the Israeli government to recognize the legitimate rights of Palestinians. My journey in understanding some of this issue began in 2019 when I saw a film about adolescents and how they were being treated and detained by the Israeli police. The adolescents I saw reminded me of this youth that I taught during my teaching years. And now I can see it on film and in the news. This causes me sadness. I attended a presentation by farmer Daoud Nasser. He described the destruction of his farm, the olive trees, and the crops, and the impossible building codes so that they couldn't build if they were in the Palestinian area. I grew up on a farm. I'm a gardener. I felt his distress. This book, the Israeli lobby regards what's going on in Virginia, and it was published in 2019. I joined a book club. I don't understand a lot about commercial and all of that, but I did learn that the state governments, as it says, it's the rise of states, the Israel lobby entering the state government. So that's more of the business commercial topic. I looked at the history, and that's what I wanted to focus on. And my handout has all the dates, but what I want to focus on right now is that both Jews and Arabs, ever since 7/11 and on through history, both groups through the Crusades, the Ottoman Empire, have been people who were displaced from their lands. So Jews and Arabs have both desired to return to their homeland. 1897 is a marked turning point when Theodore Herzl started the first Congress, first Zionist Congress. And the Balfour Declaration in 1917 officially recognized the Jewish people's natural right to reestablish sovereignty. Sovereignty is key in their homeland. That's part of what the Palestinians are trying to do to return. I found a letter written by David Ben-Gurion, 1937, 10 years before the state of Israel was declared. And he wrote to his son after their meeting when they were talking about having a Palestine divided into Jewish and Arab areas. He wrote his son, the greater the Jewish strength in the country, the more the Arabs will realize that it is neither beneficial or possible for them to withstand us. It will be possible for Arabs to benefit enormously from the Jews, not only materially, but politically as well. Oh my gosh, I see why she was upset. The rest of my notes are in the handout I gave, and I thank you for your attention.
Hold on just a moment and see if we have any questions from other
Yes,
senators.
thank you.
Thank you. Senator Hunt.
Thank you. In just your own words, we have your handout here,
Yeah.
we have your testimony. Can you speak to the position that supporting BDS is anti-Jewish or anti-Semitic?
Actually, I end my comment like that.
Well,
because-
I'd like you to speak yourself.
I believe after all the things I've studied in history and just trying to figure what's going on, and being anti-military police, anti-funding all of the military is not the same as being against the Jewish people. And when I heard some proponents talk about the BDS being coercive, I need to study more up on that because that's not my view of BDS. I don't know if I answered your question.
Yeah, thank you, sister.
Okay. I'm not anti-Semitic. Jesus was a Jew, so, Okay.
Thank you, Senator Hunt. Are there other questions? See none. Thank you for your testimony. Are there other opponents? Thank you. Welcome to the Government Committee.
Thank you. Good morning. Chairman Pro Tem and members of the Government, Military, and Veteran Affairs Committee. I am Keith Nelson, KeithNelson, and my home is in Omaha, Nebraska. I am here to speak in opposition to LB 343, which seeks to put a gag on speech to silence the voices of persons and companies. Note, the Supreme Court has determined there is no difference between person and company when it comes to freedom of speech rights, who are concerned and appalled by the dysfunctional neighborhood known as Palestine, Israel. What is happening daily in Palestine, where in 1947 the U.S. established Israel, is heartbreaking. Perhaps you know of a neighborhood which was disrupted when new residents of a different culture, color, religion, style of life, and customs moved in. People already living there have lives, routines, disrupted. When I traveled to Israel to visit holy sites, I was privileged to have face-to-face conversations with Israeli and Palestinian citizens. I visited neighborhoods in the Israeli territories, the West Bank, and in Palestinian cities, villages, and, believe it or not, still existing refugee sites established in 1947 and again in June of 1967 for displaced Palestinians. I was shocked and saddened. The neighborhoods and settlements on Israel-claimed land in Palestine are tents. Pristine neighborhoods, parks, and agricultural fields are guarded by armed Israeli military. Police stop citizens asking for papers. Tourist buses are searched. I was on one of those buses, and I have no idea what they were looking for, but I do know we had to pass through a heavily guarded gate to travel to the other side of the wall, separating Israeli-claimed neighborhoods from areas like Augusta Victoria Hospital in Palestine. The boycott of Israel is an attempt, much like citizens have used boycotts over the years since the Boston Tea Party, to call attention to injustice. In this case, the denial of Palestinian rights and encouraging governments to take action to address and correct these problems. A private individual, person, or company, but not a government, is allowed to use its purchasing power when it wishes as freedom of speech. Do not advance LB 343, which stops businesses which the Supreme Court of the United States says are the same as people seeking contracts with any Nebraska government or unit from boycotting Israel and seeking to advance the pursuit of justice for Palestinians. A business, company, or individual seeking and succeeding is establishing a contract with the state of Nebraska while mounting a boycott of Israel is a right guaranteed by the First and the 14th Amendments of the U.S. Constitution. This is a civil, national, law and justice issue. Thank you very much for your attention. I apologize for running over, and I welcome any questions that you may have.
Are there any questions? See none. Thank you for your testimony. Are there other opponents? Welcome to the Government Committee.
Thank you very much. I'm glad to be here in front of the Governmental Committee. My name is Doug Patterson, DOUG-PATERSON. It's one T. Senator Julie Slama's LB 343 seriously violates the Republican Party's historical refusal to use state power openly to coerce the private sector. Arising from her extensive ignorance of the Palestinian-Israeli Zionist struggle, she threatens to boycott companies that don't stand with Israel as she does, but which do business with the state of Nebraska. She says, if you attack and seek to delegitimize our friend, the state of Israel will not do business with you. This from a party that clearly rejoices in big government as long as big government does precisely what the party wants. Full disclosure, I'm not a supporter of Israel's 75-year policies toward the Palestinian people. I've gone to Palestine several times and Israel. I've seen the kind of catastrophe those policies are creating, including to Palestinian Christians. But note, I'm not a friend of Palestine. It's not personal. It's truth and justice. Still, forget the challenge to corporate freedom of speech and subsequent legal peaceful action. Forget the actual pettiness of this needless antagonism with no benefit to Nebraska or our citizens. Forget the fact that it seems sure that Senator Slama gets many of her political ideas from the right-wing, highly corporate American Legislative Exchange Commission, or ALEC, but not a very smart ALEC. The real question is, where does this kind of personal do-gooderism end? What if Senator Slama has a friend in Burma, Iran, or with big oil? Does she want us all to ignore the historical complexities of international and business relations so that she can be a good person? In fact, at Alex's instigation, Big Oil has now called precisely for sanctioning any company that promotes carbon neutrality. Their reactionary strategy copies almost exactly Slama's proposal to coerce companies that aren't in lockstep with their friend. Staggeringly, the bill is now the ALEC boilerplate for states to sanction private business, to punish free speech, and to go to ideological war within the United States. So what happened to the GOP that championed the free market, that championed the smaller, less intrusive government? I guess that GOP is dying in the unicameral. Thank you.
Thank you. Are there any questions? Yes, Senator Hunt.
Thank you, Senator Sanders. Thanks for being here, Dr.
You
Patterson.
bet.
Can you speak to the claim that supporting BDS is anti-Semitic?
My sense of it is there's an organization in the United States called AIPAC, the American Israeli Political Action Commissioner Committee. And AIPAC has been the lead lobbyist for Israel. And one of their tactics has been to take the whole notion of criticizing Israel about anything as anti-Semitic. So I am clearly being anti-Semitic if I'm disagreeing with Israel's policy and behavior. And that's such a warping of language. I'm not anti-Semitic. Of course, I don't want to say how many Jewish friends I have, but it's a lot. But anti-Semitic. I am critical of a state that is out of control when it comes to what it's done to the Palestinian people. I'm critical of it. That does not make me anti-Semitic.
Thank you.
Are there any other questions? See none. Thank you for your testimony. Welcome to the Government Committee.
Thank you. Good morning. My name is Rhonda Brubaker, RHONDA BRUBACHER. And I live in Lincoln. My husband, who is an Old Testament professor, and I lived in Israel for almost 5 years, working and teaching in an ecumenical institute between Jerusalem and Bethlehem. Our colleagues were Jewish, Christian, and Muslim. Our daughter, Sarah, who's 32 years old, was born in Jerusalem. We have returned there with Nebraska college students and to do archaeological work in conjunction with Israel. I've also returned to do peace work with an ecumenical organization. I believe this bill, along with similar bills being pushed in other states across the United States and likely drafted and advanced by outsiders, is introduced without real knowledge of the situation on the ground in Israel-occupied Palestine, the West Bank, and Gaza. And there's many organizations that document these things, Jewish Voice for Peace, for example, and the UN. As an American citizen and resident of Nebraska, I do not want our state legislating unconditional support for a foreign government, ally or not, that imposes on our constitutional right for political free speech, whether as an individual or a business. Thank you.
Thank you. Let's see if there's any questions. Senator Hunt.
Thank you, Senator Sanders. Do you have a typed copy of your remarks?
I do not, but I can provide one later.
I would love to have that via email if you can send that.
I will do that.
Thank you.
Thank you. Any questions? See none. Thank you for your testimony.
Thank you.
Welcome to the Government Committee.
Thank you. My name is Dwight Williams, DWIGHT, WILLIAMS. I serve as pastor at New Life Presbyterian Church in Omaha. I wish to speak against LB 343. As a pastor, I am concerned that this bill is an infringement of our First Amendment religious rights, as well as our free speech rights. I'm an ordained minister in the Presbyterian Church USA, the largest Presbyterian denomination in the United States. Let me be clear, Presbyterians do not wish the destruction of the nation of Israel, but we do want ethical behavior and human rights. The highest governing body in the denomination, the General Assembly of the Presbyterian Church, in its 220th annual meeting, voted with a 71% majority to boycott all Israeli products coming from the occupied Palestinian territories. At its next General Assembly meeting, we voted to divest from 3 American companies doing business in Israel-Palestine. Last year, our General Assembly voted that the Presbyterian Church USA recognizes that the laws, policies, and practices of the government of Israel regarding the Palestinian people fulfill the international legal definition of apartheid. Presbyterians are not the only religious communities who have officially voted to boycott, divest, or sanction the state of Israel. We are joined by Mennonites, the United Church of Christ, the United Methodist Church, many Quaker bodies, the Unitarian Universalist Association, and others. I've been to Israel, and I have seen how the Palestinian West Bank has been slowly and steadily overrun by Israeli settlers. Israelis have built illegal settlement upon illegal settlement, and Palestinian families who farmed the land for literally centuries have been forcibly pushed off their ancestral lands. In 1922, about 11% of Palestinians were Christian, and they are also Semitic. Today, the number is less than 2% in the nation of Israel. What happened? Former Congressman Henry Hyde said in 2007, expanding Jewish settlements in the West Bank, including East Jerusalem, are irreversibly damaging the dwindling Christian community. Illegal Israeli settlement in the occupied West Bank should be no surprise to us. And in 1937, 11 years before the creation of the State of Israel, David Ben-Gurion, recognized as the founding father of the modern State of Israel, wrote to his son, and Cynthia referred to this letter. He said, what we really want is not that the land remain whole and unified. What we want is that the whole and unified land be Jewish, with the ultimate goal to settle all parts of the country. In the 1940s, Ben-Gurion was asked, what is to be done with the Palestinian population? Ben-Gurion waved his hand in a gesture which said, drive them out. Will you, the legislators of Nebraska, take away my ability to criticize a nation for what I understand is illegal behavior? Thank you for letting me speak to you today.
Please finish. I think you have another paragraph.
I understand that other states have made this type of law, but I would hope that the wisdom of Nebraskans won't initiate the same type of trespass against law-abiding citizens. Thank you.
Are there any questions? See none, thank you.
Thank you.
Welcome to the Government
Senator?
Committee.
I recommend Robert Romaley, R.A., R-O-B-E-R-T, R-A-M-A-L-E-Y. I recommend that LB 353 not be advanced. I speak as a concerned member of the Religious Society of Friends Quakers. The American Friends Service Committee, which is a service arm of the Quakers, has strongly endorsed the use of BDC, pointing out the apartheid practices of those being used in the state of Israel against their own Palestinian brethren. The use of BDCs is with a resort to not having to use war to settle differences. And it has been very effective. In fact, I've used it myself to help Jewish communities in South California. But you can demonstrate this very easily by seeing what happened in South Africa. The two sides were irrevocably locked together, and it became embarrassing and economically punishing to the government of South Africa to continue on having this situation. And it was resolved, and it has been a very effective tool, and we as Quakers have used it many times. And actually, the bill before you is not, it actually is almost anti-Semitic itself, because it says these people are better than anybody else, and you are not. And that includes the long history of anti-Semitism, even in Nebraska. Thank you for your attention.
Let me check if there are any questions. Are there any? See none, thank you for your testimony. Are there other, we're on opponents? Welcome to the Government Committee.
Thank you so much, Senator Sanders. Good morning, good afternoon, actually. My name is Kevin Bushnell. It's Kevin Bushnell. And thank you so much for taking the time to listen to our testimonies. I have a short prepared testimony, so I'll just read that quickly, but also have some extraneous remarks as well. So I strongly urge the committee to vote against LB 343. I'm here today as a native Nebraskan. I've been born and raised in Omaha, but I've had the opportunity many times to visit and work in a nonprofit capacity in both Israel and Palestine. And I, of course, like so many others, speak out as a concerned citizen as well on the issue of perhaps the way this legislation is going to restrict free speech for Nebraskans. I think it was right and correct to point out how the case of Citizens United from the Supreme Court has equated corporations and businesses with individuals. And not only that, but free speech with money. So money, free speech, corporations, businesses, and people are all together in some of these issues. And so this issue is of LB 343 is directly ties all those together, but here in the state of Nebraska. So this is why I want to urge the committee to not vote for it. But I also speak as a Christian who's appalled by the multiple human rights violations that regularly occur in part of the government of Israel against Palestinians. As I said, I have had plenty of opportunities in the past 20 years. Multiple times to witness actions on by this government against many Palestinians. I've worked in different parts of the territories, including the city of Hebron, but also in Jerusalem, East Jerusalem, Bethlehem, and the surrounding areas as well. Also, I'm a member of the Committee of Social Justice and Peacemaking for the Presbyterian Church here in the Presbytery of the Missouri River Valley. We met on Tuesday and we were unanimous in support against this, just so I hear as represented in that capacity, we were unanimous against voting for LB 343. So I think that I'd like to thank the committee for its time and attention to this matter. I'm available for any questions along the lines or any clarifications for anything that's come up. So.
Are there any questions?
No.
See none, thank you for your testimony.
Thank you so much.
Are there any others on opposition?
I'm not sure if it's good morning or good afternoon.
It's good afternoon and welcome to the Government Committee.
Well, good morning to the committee that's left here. And I'm sorry, I feel like I'm losing a little bit of my rights not to be talking to the whole committee. I'm sorry that had to happen today. Being here today, I'm having deja vu. Last year, about the same time, the senator here was presenting LB.
I need your first and last name and to spell it as well.
Forgot it last year too.
Thank you.
Sandra, Sandra, and Hannah, Hanna.
Thank you.
Last year, about the same time, the senator was presenting LB 845. Today, although the legislator bill is numbered LB 343 and carries a different name, it is the same basic bill that did not pass out of this government Military and Veteran Affairs Committee last year. I am thankful for that, not in an angry way, but just a very thankful because I have been to Israel and Palestine. I have seen the suffering on both sides, and I am really concerned about a people under occupation. Although there are also Israelis who may feel that way as well. The name of the bill last year was the Anti-Discrimination of Israel Act. This year, the name is Prohibit Public Contracts with Companies that Boycott Israel. Both titles insinuate that the country of Israel is being mistreated. The first bill title indicates that discrimination toward Israel should stop, while the second one now says boycotting Israel should stop. Those are two very different things. One needs to examine the definitions of both words in the context of the titles. Discrimination means unfair treatment of the foreign country of Israel, while boycotting means using a United States First Amendment right of freedom of speech, which that freedom of speech is a nonviolent, peaceful tool to eliminate human rights violations. In this case, Israel's violations toward both Israel's Palestinian Muslim and Christian citizens and the Palestinians of both faiths under occupation in the Israel-controlled territories. The real question for me about this bill is it a necessity? And secondly, is it legal? Do we Nebraskan citizens want companies who sign contracts with our state to give up their given right of the U.S. Constitution's First Amendment of free speech, known in part as collective political speech or boycotting? That's the correct term there, in order to work for our state? Or is this bill designed to keep the foreign country of Israel from getting criticism for the human rights violations it is committing? Israel consistently breaks international law and even some of the Geneva Convention.
Do you want to go ahead and finish your sentence?
Yes.
Please.
The convention. The UN and justice organizations throughout the world, even those in Israel itself, have verified the violations.
Thank you. Are there any questions? Senator Hunt.
Thank you, Vice Chair Sanders. I can see that you're almost done with your statement. Would you like to finish it?
I would love to.
Thank you.
Thank you. As the senator told us last year, Israel and the state of Nebraska have already enjoyed a profitable economic relationship for years. So apparently having last year's bill not pass out of this committee made no difference in Nebraska and Israel's very profitable business relationship. A number of the proponents pointed that out before me. In the questions the committee members raised last year, we also learned from the senator that no companies applying to work for Nebraska's contracts had brought up the subject of boycotting Israel, making the subject of this bill a non-existing problem. I hope you committee members will ask equally hard questions today, and thank you very much for your dedicated work.
Thank you. Thank you. Are there any other questions? I just wanted to, the other committee members who had to leave wish they were here.
Oh, and I know
we are
that.
just trying to split our time and get everything done in the 90 days.
I appreciate that, and I
Apologize.
hope they'll read what
Yeah,
we've handed in.
Absolutely. We keep these all for them when they're done in their other meeting, but thank you for your testimony.
Thank you.
Thank you. Are there other opponents?
Good morning.
Good afternoon.
Good
Welcome to the
afternoon,
government
members.
committee. Thank you.
I very much appreciate you listening to what I'm going to say. My name is Sharon Conlon, Conlon. While others here have been speaking about our First Amendment rights and the freedom of political speech, I want to widen this aperture and give a context for my opposition. I want to challenge the framework of American exceptionalism. In this frame, our U.S. behavior is only doing good as we promote democracy and freedom around the world. Human rights violations are the product of our adversaries like Russia and China and Iran, but not us. But when we have the rare opportunity to hear the voices of people in the global South and elsewhere who experience our foreign policy, we are reminded that America is not always a beacon of democracy and freedom. America is a country that sends drones over their territory. America is a country that arms and supports the dictators who oppress them. America is a country that imposes broad-based sanctions that make it hard for civilians to get medicines and basic necessities in countries such as Cuba with a long history of sanctions. When we recognize that the United States is fully capable of human rights abuses, if we are introspective and focus on our violations, the next step is to question the abusive behavior of our allies, governments like Israel and Saudi Arabia. And that's where Israel comes into focus. We have to be concerned about the billions of dollars in unconditional military aid to this government that oppresses its minorities. Even Israel's own leading human rights organizations, B'Tselem and Yesh Den, have documented that Israel is practicing apartheid. And the world's leading human organizations, such as Human Rights Watch and Amnesty International, have said the same. You may say we shouldn't be boycotting our allies. And I say we should be boycotting Israel and Saudi Arabia if that will get them to change their long histories of human rights abuses. So I urge you to oppose LB 343, and please then step aside and let the public use their own political voice to get these countries to comply with international law.
Thank you. Are there questions? See none, thank you for your testimony. Are there any other in opposition? How many more do we have in opposition? How about in the neutral? Thank you. Welcome to the Government Committee.
Good afternoon. Daniel Gutman, Gutman, on behalf of the ACLU. Unfortunately for me, I have lost my voice, but that's probably fortunate for you. I am passing around a one-page sheet on the ACLU's position, and I would refer to that. The ACLU opposes this bill for the reasons in the handout. And I would take any questions. Maybe.
Are there any questions? Senator Hunt.
Mr. Gutman, I'm sorry to ask you a question
It's
when
okay.
you've lost your voice, but can you speak to the claim that supporting BDS is anti-Semitic and/or to the difference between discrimination and boycott?
On the second point, the ACLU has serious concerns, First Amendment concerns, with prohibiting or government interference in any sort of boycott, whether it's Israel or anything else. Our concern is that you could take out the word Israel and put in literally any other country, any other organization, any other person, and that would be a clear prohibition on freedom of expression. And so that is our primary concern with the bill. We think we have that Nebraskans have a First Amendment right to boycott no matter what they're boycotting. So that's our constitutional concern.
Thank you.
Thank you. Any other questions? See none. Thank you for your
Thank you.
testimony. Take care. Anyone else in the opposition? In the neutral? See none. We'll have a closing on LB 343. We do have a summary report, LB 343, proponent 6, opponents 12, neutral 0. Thank you.
Had worse ratios before. Thank you, members of the Government Committee who aren't in Executive Board. It is a privilege to present this bill before you today. Just a couple of quick tiebacks to some of the opposition testimony before we wrap up. The ACLU, in pushing their claim that this bill somehow restricts free speech, they've lost every time they've brought that to the Circuit Court of Appeals. The Eighth Circuit voted en banc 9-1 in the Arkansas case, as I referenced. It's been made clear that this does not infringe upon speech. It is simply a state government decision as to how they're going to operate. I've also been to Israel and Palestine. I've had the chance to meet with the Palestinian government officials. I had the chance to go over there for a summer in a joint program with West Point. So I am very aware and appreciate the geopolitical situation in the Middle East, in large part thanks to being able to go over there and visit for a time. It was wonderful. Nobody's pushed this bill on me. Nobody's brought this bill to me. That claim's just false and a little bit offensive to my capabilities as a senator. I wanted to get that on the record. And I'm happy to work with anybody on the committee, answer any of your questions. I think this is critically important as we look at the overwhelming majority of states that have already passed this, that we show that Nebraska is an ally of our friends in Israel.
Thank you. Are there any questions for Senator Slama? See none. Thank you very much for bringing this bill. And this closes the hearing on LB 343.
I was just wondering